So good morning, everyone, and thank you for joining us for the Medical Board of California Panel B meeting. Pursuant to the provision of Governor Gavin Newsom's Executive Order N29-20, dated March 17th, 2020, this meeting is being conducted via WebEx. If you are having difficulty hearing the audio of this meeting, it could be because the device you're connecting with has bandwidth limitations. If you do have difficulty hearing the audio of this meeting using your device, please click the ellipsis button at the bottom of the WebEx application or the audio and video menu item at the top of the WebEx application, and then select Switch Audio. You will see an option to call in and will be provided with a telephone number, access code, and attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you joined the meeting with. By using this method, if you are having audio problems with your device, this will allow you to still participate and hear the audio of the board meeting. Please see the instructions on how to connect link on the last page of the meeting agenda for step-by-step WebEx instructions, including screenshots. Thank you, Dr. Thorpe. You can now start the meeting.
Thank you, Sean. Good morning, Panel B, and Judge King and Council. We are, as I said earlier, we have a full agenda. And so we are going to go ahead and call the meeting to order at 8:14. And Carrie, if you would call the roll, please.
Good morning. Mr. Brooks?
Present.
Ms. Campoverde?
Present.
Dr. Hielzer?
Present.
Ms. Lawson?
Here.
Dr. Mahmood? Dr. Thorpe?
Here.
And Dr. Thorpe, I did just receive confirmation from Eric, our DC manager, that Dr. Mahmood will be joining momentarily. So hopefully we see him here shortly.
Okay, great. All right. All right. Well, Judge King, I think we will turn the meeting over to you and allow you to proceed.
Okay. So the first, am I unmuted? Can you hear me okay, Dr. Thorpe?
Yes, we can.
Okay, thank you. The first matter called this morning, and I hope I don't mess up this last name, it's Dr. Marcinkus. And I believe I saw him in the room as well as Mr. Garcia and Mr. Hagan from the AG's office.
This is Judge King. I'm working on adding them all here right now.
Okay.
Got the council. I did see Mr. Marcinkus here earlier. Not seeing him.
I saw him towards the bottom of the participant list.
There we go. Okay, so you should have all parties. I did have multiple email addresses for Mr. Garcia, so I've added multiple connections I saw from him. Okay. So maybe.
Or just ask Mr. Garcia, can you confirm that you are on the call and you can hear us okay? And Mr. Garcia, if you can hear me, if you're speaking, we can't hear you, so you need to make sure you unmute your microphone. Okay. Deputy Attorney General Hagan, are you on the call?
Yes, Judge.
Okay, thank you. And Mr. Garcia, are you on the call?
Try adding.
I see Albert Garcia on there. It looks like he's muted. Am I allowed to unmute him, or is that something he needs to do himself?
Yeah, I hit the request button for him. He should be getting a pop-up on his side. I just saw a second Garcia that I'm trying to add, so I don't know if one's connected audio, one's not, it looks like right now.
Okay. And Dr. Marcinkus, are you present on the call?
Yes.
And am I pronouncing your last name correctly, sir?
Yes.
Okay.
Correctly. Thank you.
Thank you.
Albert Garcia, can you hear me now, Albert Garcia?
We can hear you, sir. If you can maybe get a little closer to your microphone or speak a little louder, you're kind of soft and cutting in and out.
Okay, I was unable.
Mr. Garcia, I think you have a second device connected, and then audio is creating that feedback loop. If you could either turn that second device down or off completely, we can hear you through the one you're talking to right now.
I don't know how to do that.
Here, I will remove your second connection here, and
Now can you hear me?
yeah, there we go. No feedback that way.
Yeah, Judge, I'm sorry, members of the panel, I apologize, but I was unable to unmute myself here for the first few minutes.
Okay, but you have control of that now, and I did confirm your client is present on the call. I don't know if he's in the same room with you or in a different, calling from a different location. Is everybody ready to proceed?
Yes, Your Honor, on behalf of the respondent, Albert Garcia.
Okay, and Mr. Hagan, you're ready to go?
Yes, ma'am, I am.
Okay, thank you. Ms. Melgren, if we could please go on the record. Good morning, everyone. We are on the record before the Medical Board of California in the matter of the accusation against Rim Marcinkus, MD. This is board case number 800-2020-067406. OAH's case number is 2022-01-0239. Today is February 10, 2022. The time is approximately 8:20 in the morning, and this hearing is being conducted by video conference through the WebEx application. This is the date, time, and place set for oral argument in the notice of hearing. My name is Tiffany King. I am an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over this matter. Prior to going on the record, the board members identified themselves and a quorum was established. If I could please take the appearance of counsel, beginning with the Deputy Attorney General.
Good morning, Your Honor. Martin Hagan from the Attorney General's Office, appearing on behalf of the complainant, the Medical Board of California.
Thank you.
Good morning, Your Honor, Albert Garcia, appearing on behalf of the respondent, Dr. Marcinkus.
Thank you. And I will note for the record that Dr. Marcinkus is also present on the call. Okay, in this matter, the board has issued an order of non-adoption of a proposed decision by an administrative law judge and has decided to determine the case itself. The board has invited particular discussion of whether or not that order should be modified, the proposed order should be modified. The following process and time limitations will apply. Respondent will have 15 minutes to make an opening argument. The Deputy Attorney General will then be given 15 minutes for a response. Respondent will have 5 minutes for a closing argument, and the Deputy Attorney General will then be given 5 minutes for his closing argument. These time limits will be strictly enforced. I will interrupt counsel and give them a 1-minute warning. I will remind counsel the argument should be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but cannot ask questions that would elicit the introduction of new evidence. Myself or any member of the panel may ask a party to support their oral argument on a matter specific with a specific citation to the record. At the end of oral argument, I will offer Dr. Marcinkus an opportunity to address the panel regarding the proposed penalty. If respondent does elect to address the panel directly, I will swear him in beforehand. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will receive it sometime in the mail in the future. And again, I remind counsel to only base your arguments on the existing record and don't introduce new evidence. And please be advised the panel members have already had the benefit of reading your briefs. So at this time, Mr. Garcia, I will turn it over to you for your opening. You have to, yes.
Before you officially start, I just wanted to let council know that now that you've been promoted to the speaking roles, you can hit start video if you're interested in doing that. It's down by your mute button. If you have a video camera equipped device, you can hit start video if you'd like to also be on video. Thank you.
Okay, thank you. Mr. Garcia, are you ready to go?
Yes, Your Honor, thank you very much. Thank you.
Whenever you go ahead.
Morning, Your Honor. Good morning, panel members. I'm going to limit my remarks to 3 items. And the first deals with the factual findings and credibility determinations made by the administrative law judge. And the remaining 2 points deal with legal issues that were posited for determination at the hearing litigated at the hearing, and ultimately resolved by the ALJ. As to factual findings and credibility determinations, the motif running through this accusation, this second amended accusation and petition to revoke probation, is dishonesty. Charges of dishonesty pervade the pleading in a recurring pattern in various causes for discipline. So I've been doing medical board defense work for a long time and long enough to know why a prosecutor would craft the accusation in that manner. It's because findings of dishonesty are, rightly so, taken very seriously by the board and are, based on my experience, statistically more likely to result in a revocation. So the accusatory pleading here is suffused with allegations of dishonesty. But that was just what they were, allegations. And those allegations were tested, evaluated, assessed in a 2-day hearing in which the ALJ had the first-hand opportunity to listen to the testimony and to determine whether the assertions of dishonesty were credible and supported by the evidence. And what did the ALJ find regarding those claims of dishonesty? Again, I'm not going to repeat what I've already written, but factual findings regarding the claim that respondent was dishonest or deceitful of submitting the quarterly declarations. The ALJ made specific findings on that issue and said neither was established. Neither was established. Respondent credibly testified that he did not believe it necessary to disclose the Nevada discipline, for example. There was a situation where the respondent had been disciplined by Nevada and then failed to disclose it on his quarterly declaration. Respondent credibly testified that he did not believe it necessary to disclose this because Nevada was taking reciprocal discipline based on California's discipline, of which the board was already aware. And it goes on to say the respondent failed to disclose the Nevada discipline, but he did not intend to deceive or lie to the board. Factual finding, credibility determination. Now, the other one has to do with practicing while a CPO order was in effect. That's a cease practice order. And again, the ALJ says complainant argues that respondent's practice of medicine during the pendency of the CPO were dishonest or corrupt. Clear and convincing evidence did not establish either dishonesty or corruption. There was no evidence to refute respondent's contention that when he received the CPO, he canceled or rescheduled all procedures and treatments and primarily practiced in the state of Nevada, where he's also licensed to practice. So the ALJ once again concludes that respondent's conduct was not dishonest or corrupt. There was another finding on that issue. Respondent credibly testified that the name of the person accepting delivery of the CPO, this is when the respondent was served with the cease practice order, belonged to the suite next door. And the notice was misdelivered. The complainant provided no contrary evidence on that issue. That's the finding of the ALJ. Therefore, it was not established that respondent had actual notice of the CPO until at least the end of the day on December 27th. There's an allegation that he was performing cosmetic procedures before that date, after which both surgeries were completed. But no surgeries were completed during the time that the CPO was in effect. As to false advertising, there was a video where respondent identifies himself as a member of the American College of Surgeons. That was not true. He was not a member at the time the video was still on his website. But again, the ALJ found that respondent's testimony that the videos were created before his membership expired. He was a member at one point of the American College of Surgeons, or a fellow. Well, he was he had a he had a some kind of membership status with that organization. So the ALJ said his testimony that the videos were created before his membership expired, and his web designers put up the information. It was based on information that was credible. And finally, he says neither the respondent nor the individuals who maintained the website intended to mislead or deceive the public. Okay, these are the factual findings that served as the foundation for the ALJ's conclusion that while there were multiple violations of probation, and Dr. Marcinkus agreed to it and acknowledged that from day one, he did not engage in any dishonest, corrupt, or deceitful conduct. Now, we're here on non-adoption. What does this panel do with these factual and credibility determinations? And the answer lies in the Medical Practice Act, which says that when considering a proposed decision, the board or panel shall give great weight to the findings of fact of the administrative law judge. So by its use of the word shall in the above quoted provision, the legislature has imposed a mandatory duty on this panel to defer to the factual determinations of the ALJ, including the credibility determinations. And the reason for this rule is clear. The ALJ had the opportunity to actually observe the witnesses while they testified, even though nowadays we're doing it remotely as we're conducting this hearing, for example. But nevertheless, there was an opportunity to observe the witness as the witness testified, to observe the demeanor of the witness. And so he was in a better position to judge credibility than this panel is, unfortunately. This panel reads the transcript, reads the record, but doesn't have the opportunity of that first-hand experience to observe a witness on the witness stand, the mannerisms, the body language, everything that goes along with what we call demeanor on the witness stand. So that's the reason for the rule. It's a legitimate reason. So, to put it bluntly, with due respect to the panel, the law is that you cannot disregard or second guess the ALJ on its factual findings and credibility determinations simply because you don't like them. The dishonesty theme that was so carefully crafted and woven into the accusation was not established by clear and convincing evidence. It came undone at the hearing. Okay, a couple of legal questions that I thought were very important. One of them has to do with the practice monitor. Dr. Marcinkus was on probation. Condition number 5 required him to submit the names of licensed physicians to serve as his practice monitor. Quote, this is right from condition number 5. Quote, whose licenses are valid and in good standing, and who are, quote, preferably certified by the American Board of Medical Specialties. That is what the probation condition states, and that's what it requires. And again, it must be understood that this condition was imposed as part of a stipulated settlement. The parties, and Dr. Marcinkus in particular, entered that agreement based on the terms that were spelled out in that settlement agreement. This was a contract between the parties. And as such, the law says that one party cannot unilaterally add conditions and requirements that were not part of the agreement upon which the parties initially agreed, upon which they came to a meeting of the minds. Yet a probation monitor in this case, Ms. Holt, testified that according to certain undisclosed, at the hearing, undisclosed protocols, physicians who have passed disciplinary action or open investigations are, quote, automatically disqualified to serve as practice monitors. He testified that it was a board policy not to approve practice monitors who had previous disciplinary history or other complaints. And she produced a form to that effect, some printed form that said that. The problem is that that's not what Condition 5 says. Condition 5 simply says, it doesn't say anything about a pending or past disciplinary action or an open complaint or complaints closed due to insufficient evidence. It just says, give us a name of a physician whose licenses are valid and in good standing. That's all. And Dr. Marcinkus provided some names of people who had passed discipline and they were disqualified, even though their licenses were, at the time their names were submitted, in good standing. I have a real problem with this. This is the enforcement unit going beyond its authority, imposing requirements on the qualifications of a practice monitor that go way beyond what this board authorized and adopted, duly adopted, under the Administrative Procedure Act as its disciplinary guidelines. I think this was an underground, what we call an underground regulation, and it's unenforceable. Issue number 1 in law. Issue number 2, revocation. It's not mandated by this BMP Code Section 2306. The complainant says, Dr. Marcinkus was practicing during the time that the CPO, the cease practice order, was in effect, and under this statute, automatic revocation, automatic. Well, I'm not going to go through a lot of detail, but the judge got it right. He went through Business and Professions Code sections 22, 27, and a suspension is a disciplinary sanction that the board is authorized to impose on a licensee, number 1, who is found guilty after hearing, or whose default has been entered, or who has entered a stipulated settlement. It has a very specific meaning. A suspension is a term of art within the board's arsenal of disciplinary sanctions, and it requires, under the clear and unambiguous language of Section 2227, either evidentiary findings or an acknowledgement of admission of cause for discipline as a jurisdictional predicate for its imposition. So the legislature here chose to use the word suspension or suspended in this code section 2306. The mandate for revocation therefore applies only in those situations where the licensee, during the term of a suspension, is found to have been engaged in the practice of medicine. The legislature did not say during the term of a cease practice order. And it certainly could have, because it knows how to say it, and it has said so. It has used that very term, cease practice order, in other legislative enactments. So the legislature knows how to say that. It knows the difference between a suspension and a cease practice order. So the mandate of Section 2306 does not apply because respondent's license was not suspended, as that term is defined in Section 2227, and respondent therefore did not practice during the term of his suspension. Two legal issues that I think are very important to this case. Mitigating circumstances. Dr. Marcinkus, he candidly admitted, look, I was a terrible probationer. I was not the model probationer. He was late submitting quarterly declarations. He did a lot of things that were, wrong. He testified that he had financial issues. I'm sure you've heard this before. It's very expensive to be on probation. You have the monetary costs, you have the cost of the PACE program and other related courses. So I'm sure you've heard that excuse in the past. It's not unusual, but he said, I had financial difficulties. Once you go on probation and you're on the website.
Mr. Garcia, you have 1 minute remaining.
Thank you. Once you're on the website there with your probation disclosed to the public, people start canceling their appointments with you. So he talked about that, about his financial difficulties in meeting his probationary obligations. There was evidence of his substantial work, volunteer work, both here and in Lithuania. He had letters of reference, letters of testimony from character witnesses. So what we're left with at the end is, yes, he was not the ideal probationer, but he complied with all the terms and conditions of probation ultimately. So what you're left with here after you dismiss the dishonesty charges is probationary conditions that were not complied with, but that do not warrant the extreme sanction of a revocation. Thank you very much.
Thank you, Mr. Garcia. Mr. Hagan, are you there?
Yes, I am.
Your 15 minutes begins now.
Thank you. Good morning. May it please the board. I'm Deputy Attorney General Martin Hagan. I represent the complainant, the Medical Board of California, in this matter. My argument will focus on what the notice asked the parties to focus on, and that is whether the degree of discipline is adequate to protect the public in this case. As will be discussed in more detail, this case involves respondent's history of repeated misconduct dating back to 2011 as set forth in his prior discipline. Respondent's numerous violations of the terms and conditions of his probation and respondent's new discipline as set forth in the second amended accusation and proposed decision before the board, which includes respondent's willful and repeated violations of the board cease practice order, respondent's multiple false statements, respondent's false or misleading advertising, respondent's out-of-state discipline, respondent's failure to have a fictitious name permit for his outpatient surgery center, respondent's failure to maintain adequate and accurate records, and respondent's general unprofessional conduct that was unbecoming a member of the medical profession. Despite this substantial and concerning record of misconduct, the administrative law judge assigned to this case imposed extremely lenient discipline, which consisted of 1 additional year of probation and a 30-day suspension. Clearly, this iota of discipline fails to adequately protect the public. As the board is aware, Business and Professions Code section 2001.1 provides that protection of the public shall be the highest priority of the Medical Board of California in exercising its licensing, regulatory, and disciplinary functions, and whenever the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. This clearly is one of those cases where another interest, such as attempting to rehabilitate respondent, yet again, would be inconsistent with the board's ultimate mandate, which is protection of the public. As a result, the board should impose revocation to guarantee that the public will be adequately protected. If the board is not inclined to revoke respondent's medical license, then it should render more severe and comprehensive discipline under terms and conditions to be decided by the board and exercising its disciplinary functions in order to protect the public. So, as far as a summary of my argument, I would like to address the following points. Number one, the ALJ's honor in imposing a lesser degree of discipline based on his finding of no intent to deceive, which in part led to a legal determination of no dishonesty under section 2234 subdivision E. I'd also like to discuss, or will discuss, why the totality of the circumstances warrants a higher degree of discipline in this case. And then my last overall point will be why revocation is the appropriate degree of discipline in this case. As argued in complainant's brief, the ALJ erred in this case in finding there was no intent to deceive, and thus there was no dishonesty or corruption, which was then used to justify his minimal discipline of 1 additional year of probation and a 30-day suspension. If you look at the plain language of Business and Professions Code section 2234 subdivision E for dishonesty or corruption, there is no language in that statute which sets forth the requirement of establishing an intent to deceive. Indeed, the recent published opinion of Davis versus Physician Assistant Board, which was cited in complainant's brief, clearly holds that state of mind or willfulness is irrelevant in determining whether discipline should be imposed. In so holding, the Davis court noted the absence of any language regarding an intent requirement regarding the statute at issue in that case, which is exactly the situation we have in this case, where there's no intent requirement set forth in section 2234 subdivision E concerning dishonesty or corruption. The Davis court also held that reading an intent requirement into the statute would not further the legislative purpose of public protection, which equally applies to this case. In this case, the ALJ's misplaced reliance on an intent requirement for dishonesty and corruption under section 2234 subdivision E was not supported under the law and resulted in a woefully inadequate penalty determination that does not adequately protect the public. So now I'd like to turn to the totality of the circumstances in this case. In determining the appropriate degree of discipline, the board should focus on the totality of the circumstances concerning respondent's misconduct in this case. In general, the totality of the circumstances establishes that respondent has no regard or respect for the general rules pertaining to the practice of medicine, which places the public at great risk. In looking at the totality of the circumstances, the board should consider the following. First, respondent is a repeat offender with a board. He was previously disciplined via stipulated settlement with an effective date of August 18, 2017. Respondent's prior disciplinary action included gross negligence and repeated negligent acts concerning 2 patients which occurred in 2011 and 2012, failing to maintain adequate and accurate medical records, using general anesthesia in an unaccredited surgery center which put his patients at risk, incompetence, lack of knowledge, and general unprofessional conduct. Respondent's previous disciplinary history is certainly a factor that supports a higher degree of discipline. In addition to establishing a record of discipline, the prior discipline is significant because it establishes a record of violating the rules that are designed to protect the public, such as not using general anesthesia in an unaccredited surgery center. Additionally, the prior discipline involved misconduct that has been repeated by misconduct in his latest, or by respondent in his latest discipline, which includes his repeated inadequate record keeping and his repeated failure to follow the rules pertaining to the practice of medicine as alleged in the second amended accusation and decision in this case. In looking at the totality of circumstances, the board should also consider that respondent's latest discipline involves a broad range of serious and repeated misconduct. And that's a factor that the board should look at heavily. Respondent's repeated disregard, the record shows respondent's repeated disregard in violation of the board's cease practice order, which occurred on December 28, 2017, January 5, 2018, January 9, 2018, January 16, 2018, January 26, 2018, February 1, 2018, and February 2, 2018. The record also shows respondent's false statements, which included false statements in his quarterly declarations that occurred on October 16, 2017, January 29, 2018, April 10, 2018, July 23, 2018, January 14, 2019, April 16, 2019, August 21, 2019, April 8, 2020, July 13, 2020, October 8, 2020, and January 2, 2021. The record in this case also established respondent's false statement on his California license renewal application of November 26, 2019, in failing to disclose his Nevada discipline, and respondent's false advertising on his website by claiming in promotional videos that he was a member of the American College of Surgeons, when in truth, in fact, he was not. This violated a rule concerning the practice of medicine, which was implemented to protect the public from false and misleading advertising. The record also established that respondent was disciplined in Nevada effective June 1, 2018 for failing to disclose his California disciplinary action to the Nevada Medical Board. Also, the record established that respondent failed to obtain a fictitious name permit for a surgery center, Desert Plaster Surgery Center, which he still had not obtained as of the date of the hearing. This rule concerned the practice of medicine that regards the fictitious name permits is designed to protect the public by identifying the name of any physician using a fictitious name, and he violated that rule. The record in this case also established respondent's failure to maintain adequate and accurate medical records, which was also one of the grounds for his misconduct in the prior discipline. And lastly, there were the 3 causes of discipline or for violation of probation, which required that he obey all laws and that he failed to fully comply with his probation terms, and he violated the practice monitor condition. As you can see, respondent's misconduct was not a one-off, but instead a steady stream of varied, repeated, and serious misconduct. Moreover, the evidence in this case established respondent's history of disobeying the rules related to the practice of medicine, all of which are designed to protect the public. The other point the board should consider in looking at the totality of the circumstances is that respondent has also flouted the rules relating to the practice of medicine, which puts the public at risk. As mentioned, respondent has established a history of disobeying the rules pertaining to the practice of medicine that are designed to protect the public. This includes his prior discipline for using general anesthesia in an unaccredited surgery center, his false advertising when he claimed he was a member of the American College of Surgeons when he was not, his practice of medicine without a practice monitor in place, which led to the cease practice order that he violated multiple times, and his failure to have a fictitious name permit for a surgery center. This is concerning, especially when one considers that respondent performs unsupervised surgeries in an outpatient surgery center where there is a risk of serious complications and outcomes. In this case, the greatest predictor for the future is respondents' past misconduct and flouting the rules, which should cause the board great concern due to the potential risk of harm to the public. The other thing the board needs to look at as far as the totality of the circumstances is that remedial efforts have failed. The probation monitor met with the respondent and reviewed all the terms and conditions of probation with him before probation started, and despite this, respondent soon began violating his probation. Respondent was required to take an ethics class, which he took, and despite this, respondent has committed additional ethical violations. Respondent was required to take a record-keeping course as part of his prior discipline. Despite this, respondent has failed to maintain adequate accurate records. The American College of Surgeons also attempted to get respondent to stop his false advertising, but despite this, respondent ignored ACS, and they were forced to file a complaint with the board. The board also brought the false advertising to respondent's attention. Respondent, through his counsel, told the board he had taken care of it, but continued to misrepresent that he was a member of ACS in promotional videos until at least May 10, 2021. Lastly, after respondent failed to get a practice monitor, which resulted in the CPO, he enrolled in the professional enhancement program through PACE and then failed to make timely payments and chart submissions, which created a greater burden on his probation monitor, the PEP administrator, and his practice monitor through PEP. Now, I'd like to discuss why probation is the appropriate degree of discipline. The board is guided by the relevant case law concerning discipline and disciplinary guidelines, as I've mentioned, that protection of the public is the highest priority of the board. And when other interests interfere with that, you must go with protecting the public. Another thing to keep in mind is the more serious the misconduct and the bad character evidence, the stronger the applicant's showing of rehabilitation that must be made. Also, as the ALJ noted, the guidelines note that the maximum penalty of revocation should be given for repeated similar offenses or for probation violations revealing a cavalier or recalcitrant attitude, would certainly apply to the facts of this case. Now, respondents' attempts to broadly argue that the board is confined to all the determination made by the ALJ is an overreach. The facts concerning respondents' misconduct are largely undisputed, and with that in mind, the question is, what is the appropriate degree of discipline to protect the public? As set forth in complainant's brief, the propriety of a penalty imposed by an administrative agency is a matter vested in the discretion of the agency, and its decision may not be disturbed unless there has been a manifest abuse of discretion. Next point is a revocation is justified because respondent's misconduct is serious and repeated over an extended period of time. I've already argued that and shown about the extensive record in this case as to the serious and repeated violations of probation and the additional new misconduct. The other point is revocation is also justified because the evidence of rehabilitation in this case is minimal. The mere expression of remorse does not demonstrate rehabilitation. Instead, a truer indication is sustained conduct over an extended period of time, which demonstrates that the licensee is fit to practice their profession. Whether respondent complied with the terms and conditions of probation, the nature and severity of the acts, and the time that has elapsed since the commission of the acts or offenses are all factors to be considered in determining the degree of rehabilitation. The bottom line is that in regard to establishing rehabilitation, actions speak louder than words. In this case, respondent's compliance with his probationary terms has been abysmal, which must be considered by the board. Moreover, the repeated nature and severity of misconduct and the limited time that has elapsed since the violations are also factors that weigh heavily against respondent and further support that revocation is the appropriate penalty. And as I mentioned, revocation is also warranted based on potential for harm to the public. Is there a potential for harm to the public? Absolutely. There's certainly a risk of harm to the public from a lone wolf plastic surgeon with his own surgery center who has consistently failed to abide by the rules and regulations pertaining to the practice of medicine and establishes his indifference to any efforts to rehabilitate him. Now, in closing, for all the reasons argued herein and in complainant's brief following non-adoption, the board should revoke respondent's license to practice medicine to ensure that the public is protected. If the board is not inclined to revoke respondent's medical license, it should certainly render more comprehensive discipline, than what is recommended in the decision under terms and conditions to be adjudicated by the board in exercising its disciplinary functions that will adequately protect the public. Thank you for your time.
Thank you, Mr. Hagan. Mr. Garcia, you have 5 minutes for your response, beginning now.
Thank you very much. Obviously, the mission. I hear an echo. Are you able to hear me all right?
I'm able to hear you okay, Mr. Garcia. I'm not receiving an echo.
Obviously, yes. Of course, the mission of the board is to protect the public, and that's a primary concern of the board. And let's look at the record here. Mr. Hagan there referred to the fact that Dr. Marcinkus was placed on probation back in 2017 for conduct that occurred. This has to do with patient care. Conduct that occurred in 2011 and 2012. 10 years removed. No new allegations of substandard care have been alleged in this new accusation. This new accusation and petition to revoke probation has to do with, and I'm not diminishing the importance of it, but it has to do with, violations. You're late with your quarterly report. You're late paying the monitoring costs of probation. You're late enrolling in PACE. You're late enrolling in the ethics course. And look, I've been doing this work for 25 years, and I see it all the time. I know you've seen it all the time. Probationers sometimes, not all, some probationers are very good and compliant, but many times probationers run into trouble. They get behind on their obligations to enroll properly or timely in these courses and to pay their monetary costs. That's what we have in this accusation, basically. And all of the charges of dishonesty, again, this is very important because Mr. Hagan just emphasized how important he thinks it is. All of the indications or allegations of dishonesty were found not to have been established by the ALJ. They weren't established. And this notion that there's no intent requirement for discipline, well, I agree with that. No one's saying that this board is without authority to discipline. I'm not saying that. No one's ever said that. The fact of the matter is that all of the allegations that concern dishonesty, the ALJ heard the evidence and assessed the evidence, and in the end said, no, I don't find any dishonesty here. So what you're left with, again, is a series of violations of probation, which I'm not diminishing their importance at all. But when we talk about the protection of the public and whether the doctor should be revoked, we have to look at the facts of the case here. No sub-patient care alleged, and the last time there was any indication of that was 2012, 10 years ago. So the notion that this is a doctor who's going to run into trouble, he's going to, he practices alone, and therefore, I practice alone. So I kind of take it. I take reference to that, but anyway, he practices alone, so therefore he's a danger to the public. Well, the fact is that the record does not bear that out. 10 years and not one allegation of sub-patient care in this case. With that, I think that the ALJ took everything into account, and remember this: once this accusation was filed, there was only 2 months left on the probation, and it's been extended by more than a year now. So Dr. Marcinkus has already served more than a year beyond the term that was imposed under the discipline back in 2017. He's already served it. And now they're going to add another year to that and a 30-day suspension. Well, anything more than that, I think, is just outright punitive. That's the way I think about it. That's the way I look at it. That's what this record indicates. Because if you're really concerned about patient care, he hasn't had an issue with that in 10 years. I'll leave it at that, Your Honor. Thank you.
Thank you very much. Mr. Hagan, you have 5 minutes for your closing argument, beginning now.
Thank you, Your Honor. There are a few points that I would just like to bring up to the board, which has been part of my overall theme in my argument, is I think that the board should be very concerned, and should the public, in regards to Dr. Marcinkus's continued consistent problems. And I'm referring to basically ignoring any edicts, orders, or directions by the board, his lack of candor, his recalcitrant attitude, and his violation of the rules that are designed to protect the public. I think you should also look at, when I talk about the violation and disregard for the board's rules or conditions, the most obvious one is the cease practice order that Dr. Marcinkus willfully violated. That's disrespectful to the board. It's a testament to the character of Dr. Marcinkus. He's also violated the terms and conditions of probation. And he's also violated the board when they provided him with directions and an edict to stop his false advertising. I mean, the American College of Surgeons tried to get him to stop. The board tried to get him to stop. But as of May 2021, he was still violating that. I also think the court should go ahead and look at the quarterly declarations. I would direct the court's attention to the record in this case with the OAH bait stamp of A95, which gives an example of an attestation that is provided at the end of each quarterly declaration. And it states, and I'll quote, "I hereby submit that this quarterly declaration is required by the Medical Board of California and its order of probation thereof, and declare under penalty of perjury under the laws of the state of California that I have read the foregoing declaration and any attachments and the statements are true and correct in every respect, and I understand and acknowledge that any misstatements, misrepresentations, or omissions of material fact may be cause for further discipline." That is at the end of every quarterly declaration that was signed by Dr. Marcinkus, despite the false statements in his quarterly declarations. I would also direct the court's attention to another exhibit, and the record site is A980. That's an OAH board thing, bait stamp. And prior to a licensee completing their application, they must certify that I declare under penalty of perjury under the laws of the state of California that all statements, answers, and representations provided are true, complete, and accurate in their renewal of their application when they are doing that. If the board would also look at the stipulation that we entered to in this case at record site Z as in zebra 62, you'll see as part of the stipulation that it indicates that Natalie Lowe, one of the board's employees, would have testified if she were called that the licensee must certify that, make that certification as part of the application process. And so I think the history in this case, or excuse me, the record in this case is very concerning. There's certainly a risk of harm to the public. Complainant believes that revocation would be the appropriate penalty, and at a minimum, more penalty and more comprehensive discipline is needed than what is provided for in the proposed decision in this case. Thank you very much for your time and your consideration of this matter.
Thank you, Mr. Hagan. At this time, I'm going to poll the panel to see if they have any questions for the attorneys. Dr. Thorpe, do you have any questions?
Thank you, Judge King. I do have a question for each attorney. Mr. Garcia, the board is I, as a member, I am very puzzled about the repeated either inability or unwillingness to comply with the discipline that was imposed previously. It is troubling to me. Why should we believe that further discipline will be of any value?
Well, I certainly understand your position. And again, from the very start, Dr. Marcinkus conceded, acknowledged that he was not the ideal probationer. We entered a stipulation where we had essentially acknowledged and admitted to each of the violations of probation. Though he was not a model probationer, I understand your concern. It's a legitimate concern. But I think overall, if you look at the essential parts of this probationary order, the most important parts, I think, in my way of thinking, based on my experience, is the PACE program, because it has to do with his competency, the ethics course, the record-keeping course, and the education course that was supposed to be, the one that calls for courses over and above the minimum for the renewal. He complied with all those things. That's really the crux of this probation. If you're going to be looking for a probationary order that protects the public, those are the conditions that I think are the most important, and he complied with all those. Yes, he was late doing things, and he signed those declarations saying, yeah, I'm in compliance, but he also gave an explanation for it. And the ALJ found that explanation to be credible. The ALJ said, look, in his mind, he was trying to comply, so he said, I'm compliant. The important thing is that he was not trying to mislead the probation officer, because the probation officer knew he was not in compliance, because the probation officer was constantly sending him emails and letters saying, you're late doing this, you're late doing that, you still need to do that. So it wasn't a matter of misrepresenting anything to the probation officer. So I share your concern, and I understand it as a legitimate one, but I think that, and again, he's already done an additional year beyond what he stipulated to initially. And now the proposed order is for an additional year beyond that, and a 30-day suspension. And we have Dr. Marcinkus on the record in the case, the hearing, indicating that, he is aware of his shortcomings in this case, and he's accepts responsibility for it, and that he will abide by future conditions of probation. But you do have a legitimate concern, and I can understand why you have that. But on the other hand, we also have to look at the fact that there have been no new patient complaints. He's on probation, and I think the public is protected, obviously, because we don't have any new complaints for 10 years now. So he's practicing safely. He's not the ideal probationer, obviously, but he's practicing safely. He's not hurting anybody. And I think the probationary term, an extension of the probationary term, with the same conditions of probation as previously imposed, including the practice monitor, would allay any concerns that the board should have about his practice.
Judge, I just have one follow-up, and that is, so the concern that I have personally is that, yes, he did it. He complied and took all these courses, but they didn't change his behavior. It didn't effectively change his ability. His record keeping was still a problem. He was still making ethically questionable decisions, and he was still non-compliant with probation. That is a real concern to it really, to us, to me, it kind of narrows down our options. We don't really want to revoke anybody's license, but this is a real concern. And I guess I would have to say I'm concerned that your answer doesn't really reassure me. I just had one question for Mr. Hagan, and that is this. I think Mr. Garcia makes a good point. There hasn't been any evidence of harm to patients in the last 10 years. And so is that correct? Is there any evidence? Yes, there's the potential, but has there been any evidence of patient harm?
Well, as far as a botched surgery or something like that, the answer to that would be no, we did not have evidence to that. But certainly, if you look at the record as a whole, what we have is one of the patients, or excuse me, somebody who complained to ACS, the American College of Surgeons. They were concerned about Dr. Marcinkus. And then when they went to his website, they saw that he was misrepresenting that he was a member of ACS. And that's what directed them to go to ACS and try to go ahead and resolve that. So, there's an issue of somebody who's been misled by the false representations. But I think the broader point is that honesty and integrity are deeply ingrained within the practice of medicine. And if you look at the scope of this misconduct in this case, it's filled with a lack of candor. It's filled with false statements and all that. Most probationers, what they're going to do is they are going to attempt to conform if they have fully rehabilitated themselves. And that certainly is not the record in this particular case. And then I guess the next question was, why on this record would the board want to put the public at risk? I mean, here's a physician who's operating on his own with his own outpatient surgery center. He hasn't filed a fictitious name permit. There's a lot of other falsehoods of what he's telling the board. You know, that's just not a good situation. And Dr. Marcinkus does not appear to have learned his lesson or done anything to modify his conduct, which should be very concerning to the board.
Thank you.
Dr. Thorpe, any additional questions?
I would just defer to my panel members.
Okay, thank you. Ms. Campoverde, any questions?
Sorry, I was trying to unmute. No, I don't. Thank you, Judge.
Okay, thank you. Mr. Brooks, any questions?
No questions at this time. Thank you.
Thank you. Dr. Hielzer?
Thank you, Your Honor. Mr. Garcia, it's my understanding that Dr. Marcinkus nominated 2 practice monitors who were deemed unqualified, one because the monitor didn't practice plastic surgery, and one because the monitor wasn't a licensed physician. This seems to be a rather cavalier disregard of the requirements for a monitor. And how can we be sure that Dr. Marcinkus will abide by probation conditions in the future if we do extend his probation?
Thank you. Yes, well, he did nominate one that was not a physician. That's true. But in terms of a specialty, the condition for probation, number 5, calls for a preferred. It says preferably someone who's board certified in the specialty. So it's not an adamant, requirement. But he did submit the names of several physicians who had current licenses, valid licenses, and who practice in this area, cosmetic surgery. But you're right, there was one that was not a physician, and that name should not have been submitted. And again, your concern is the same as Mr. Thorpe's, and that's where, how can you be sure that he's going to comply in the future? I think the answer to that is that he's learned his lesson. He's gone through this proceeding now, where the revocation was on the table there when we went to hearing. And he knew that, and so he's been under a cloud now where the potential for his license revocation has always been there. So I think that with this experience, what he's gone through, and how he looks back at his track record and says, I've got to do better. And that's what he said during the hearing. And I think that we could take him on his word that he's going to have to do better. Otherwise, his license is going to be revoked. So I think he's going through his experience that he's gone through, and the potential for the revocation of his license is such that it's going to guarantee that he's going to be compliant in the future.
Thank you. I have no further questions.
Thank you, Doctor. Ms. Lawson, do you have any questions?
I do not. Thank you very much.
Okay, thank you. Any further questions? Dr. Thorpe, anything additional?
No, thank you, Judge. I have nothing.
Okay, thank you. At this time, I will give Dr. Marcinkus the opportunity to address the board regarding penalty. Dr. Marcinkus, would you like to make a statement?
Yes, thank you so much. Good morning.
So one second, Doctor. Before you begin, I do need to swear you in. If you could please raise your right hand. Do you solemnly state, under penalty of perjury, that the evidence you will give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. Sir, the floor is yours.
Good morning, Judge King and California Medical Board panel. Thank you so much for opportunity to talk in front of you. I always wanted to a little bit briefly express that I am a third generation in medicine. My grandfather was a professor of internal medicine in Vilnius University and dean of medical faculty for many years. My dad was chief of cardiac surgery. We had 200 employees working for us, and he performed one of the first cardiac surgery in East Europe. I did extensive training in general cardiovascular and plastic surgery in Europe and USA with multiple fellowships to optimize my skills and results. I've done thousands of procedures and surgeries and always try to protect public, giving best possible care and seeking for excellent results in my surgery. And yes, I was not the perfect probationer, and I was sometimes late in payments and sending those declarations, which I was feeling, in my mind, I was trying to comply. That's why I was feeling those questions. But because of mailing problems sometimes because of old forms, because they kept changing those forms. They were delivered too late to the board. I provide for my family financially. I have 92-year-old mother and my kids, and the revocation of my license would be disaster for them too. Also, I wanted to add that, yes, I was associate member of American Academy of Surgeons till 2009, and then for some reason we forgot to pay fees, and you know, it stayed in the website until lately. What concerns the fictitious name permit, we have a permit. It's valid until June 30th, 2022. So everything is taken care of. Within last years, especially, we tried to do our best to follow all probation instructions, to take good care of charts with space, and do our best to follow the instructions of what is required. That's why I would like to ask the panel to adopt the judge decision, and thank you very much.
Thank you. I will poll the panel once again to see if there are any questions. Dr. Thorpe?
Yes, I actually do. Dr. Marcinkus, you can understand from our perspective, it is very troubling that I mean, you may be a very qualified surgeon, and I have no idea, you know, I don't know you, but the disregard for the discipline that was imposed on you over and over and over again is very troubling to me personally. And why should we believe you that now you're going to do what we've asked you to do, when for a number of years it appears that you haven't been doing that? And why should we consider additional probation rather than taking your license? Because that's really what's on the line here.
I understand that. At the beginning, probably it was difficult sometimes to understand the requirements, and that's why we were not following so correctly. But if you look with time, we did better and better and better. And lately we are on top of paying fees in time, and filing charts on time, and doing our best to take care of it. So I think this, as I said, I was not the best probationer, but you know, I was trying to comply as much as possible. And this you know, huge workload, sometimes you know, it's basically, you know, we make mistakes, and we try to correct them. So as for me, I'll try to do my best to take care of what's needed in timely fashion. Thank you.
Just one follow-up. I mean, and additionally, another concern that we have, and I think I speak for the board panel, but I'm speaking for myself, of course. Is there anywhere in your soul where you feel remorse for? Because I've not once heard you say, "I'm sorry. Please forgive me. I want to do better. I will give you my word that we'll do better." I haven't heard anything like that from you yet. And maybe that's, you know, maybe I shouldn't be saying that, but that's what we need to hear, that you are clearly willing and that you have remorse for what you did, because it's not there in what you've said so far.
Yes, sir. And probably sometimes it's difficult to express myself, but I really feel remorse that, you know, I made mistakes, and I'm trying to explain that, you know, I'm trying to fix it and be better and stay on top of things.
That's all, Judge. Thank you.
Thank you. Ms. Campoverde?
No questions, thank you.
Thank you. Mr. Brooks?
No questions, thank you.
Thank you. Dr. Hielzer?
No questions, thank you.
Thank you. And Ms. Lawson?
No questions, thank you.
Okay. At this time, this does conclude the arguments in this matter. The record is closed, the case is submitted, and we can go off the record. We are off the record. Gentlemen, you are excused, and I will get ready to call the next hearing unless Mr. Thorpe, did you want to take a break or would you like to just push on through?
How's everybody doing? Do you need a 5-minute break? Okay, let's just press on.
Okay. So the next matter we're going to call is, again, I hope I'm not mispronouncing the name. It's Choua Vang. The attorneys are Deputy Attorney General Sarah Jacobs and Peter Capitan for respondent.
Good morning, Your Honor.
Good morning.
This is Peter Capitan with Dr. Vang.
Is Dr. Vang in your office with you, sir?
Yes, Your Honor.
Okay, thank you. Ms. Jacobs,
morning,
are you here? Oh, good morning. I can hear you. If you could speak up a little louder or move the microphone closer to you.
I've got it right next to my face. Is that better?
That's much better. Thank you. Ms. Malgren, can we please go back on the record? Okay, good morning, everyone. I'm sorry?
I never went off the record, Your Honor.
Oh, okay. I thought I had said we were going off the record earlier, but that's okay. Let's go on the record. This is in the next case. And we are on the record before the Medical Board of California in the matter of the accusation against Choua Vang, MD. Board case number is 800-2017-030159. OAH's case number is 2022-01-0242. Today's date is February 10, 2022. The time is approximately 9:20 a.m. and this hearing is being conducted via video conference through the WebEx app. This is the date, time, and place set for oral argument in the notice of hearing for oral argument. My name is Tiffany King. I am the Administrative Law Judge with the Office of Administrative Hearings, and I've been assigned to preside over this matter. Prior to going on the record, the board members have identified themselves and a quorum was established. If I could please take the appearance of counsel for the record, beginning with the Deputy Attorney General.
Sarah Jacobs, Deputy Attorney General, appearing on behalf of Complainant, California Medical Board.
Thank you. Mr. Capitan?
Yeah, good morning, Your Honor. Peter Capitan of Capitan Brothers, LLP. We represent the respondent, Dr. Vang. Dr. Vang is present with me appearing via this teleconference.
Thank you. Okay, the board in this matter has issued an order of non-adoption of a proposed decision by an administrative law judge and has decided to determine the matter itself. The board invites particular discussion of whether the proposed order should be modified. The following process and time limits shall apply. Respondent will begin and have 15 minutes to make an opening argument. The Deputy Attorney General will then have 15 minutes to give a response. Respondent will have 5 minutes for a closing argument, and the Deputy Attorney General will then be given 5 minutes for her closing argument. These time limits will be strictly enforced. I will give counsel a 1-minute remaining warning and then tell you when your time has expired. I remind counsel that the argument should be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard at this time. The panel members may ask questions of the parties to clarify the arguments, but cannot ask any questions that would elicit new evidence. The administrative law judge and any panel member may ask the party to support their oral argument on a specific matter by making a citation to the record. At the end of oral arguments by counsel, I will offer Dr. Vang an opportunity to address the panel regarding the proposed penalty. If Dr. Vang elects to address the panel, I will swear him under oath first. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but shall receive it in the mail sometime in the future. Again, I remind everyone that all arguments must be based on the existing record and no new evidence will be received. And also remind you that the panel members have already had the benefit of reading your briefs. So at this time, Mr. Capitan, if you are ready, the floor is yours and your 15 minutes begins now.
Your Honor, could I first inquire the court, is the board going to consider the factual findings of Judge Brown?
The board will consider what was in the proposed decision, and because that's part of the administrative record, as well as all the evidence that was admitted as part of that hearing.
Well, then, for the record, Your Honor, I'd be objecting on the grounds of due process. Two of the basic tenets of due process are notice and opportunity to be heard. The board's non-adoption letter was, frankly, I thought very vague because it stated that written arguments were to be directed whether the level of discipline ordered was sufficient to protect the public. An oral argument was directed to the question of whether the proposed penalty should be modified. I filed a request for clarification, and the board's attorney basically, well, not basically, they just restated what the board had said. And because of that, there's no notice as to what we were doing because Judge Brown ordered or recommended no discipline at all based on her findings. The second part of the due process would be opportunity to be heard. The underlying case took over 7 days of testimony. There was over 2,000, almost 400 pages of documents, not including exhibits. We got over 1,000 pages of transcripts. I would point out that the transcripts don't include the defense in this case. The last 2 days are not included at all. And part of Detective Garcia's testimony admits 34 pages, and therefore we think the record is incomplete. I cannot possibly argue 7 days worth of testimony here today. I'm going to try to go through it as quickly as possible and address what I think are the highlights. In regard to Judge Brown's findings, I'd point out that she made a finding of credibility. She found Mrs. P not credible. And she did a very fine job, Judge Brown, in delineating why she found that. It wasn't just based on Mrs. P's demeanor, it was based on what she testified, the contradictions in her statements. And I'd point out that it's basic law that a reviewing court, and this is basically what this is right here, should defer to the credibility findings of the underlying judge unless they're completely unsupported by the evidence. And there's absolutely no way in this case anyone could say that the Judge Brown's decision on credibility is completely unsupported by the evidence. As a matter of fact, it's strongly supported by the evidence. And I think it'd be a dangerous precedent if we just ignore what the judges who actually got to see the witness and hear the witness, what their conclusions were as to the case. In regard to Judge Brown's testimony, her decision, the AG doesn't like the fact that Judge Brown concluded that Ms. P was not being truthful when she discusses these alleged sexual assaults, is what she was describing. Judge Brown wrote a detailed decision. The AG had pointed out that she's perplexed that Judge Brown at one point said these allegations did not happen, and then she blames Ms. P for letting them happen. That's not what Judge Brown said at all. Judge Brown was very clear that she did not believe these alleged sexual acts ever occurred. And she did that in a very detailed fashion. When we review the facts of the case, it was included in my closing argument, but unfortunately my closing argument is not part of the record of this case because it was given on the last day of testimony. First of all, the forum was kind of strange and I thought very unfair. We did this via Zoom or like we're doing today, and Ms. P was literally testifying from the office of her civil attorney that had filed a lawsuit in which they're claiming $3 million in damages. Whenever she was questioned in a tough way, she would feign like she was crying. They'd go off the record, shut down the computer, and then she literally sat in the office of her civil attorney with him present, because he was present throughout her testimony, and who knows what went on. When she came back on, she would then testify. At one point, I actually asked her to look into the camera, because when she looked in the camera, it was obvious that she had never been crying. And Judge Brown noted that she was feigning being emotional in tears. And that's something you had to see to understand what was going on. And when I say these things, the AG accused me and, frankly, Judge Brown of, for lack of a better term, slut shaming, that we're attacking the victim. That's not at all what we're doing. There's allegations being made, and we have to test those allegations to determine whether they were true. And unfortunately, that brings out a lot of bad things in an individual. When you look at Ms. P, the woman that went into the office that day, she was an emotionally and psychologically disturbed woman. In that sense, She was going through a divorce. She had lost her job, so she was in financial straits. She was on psychiatric medication. She got, for the year prior to this, she was getting psychiatric.
I'm sorry, Your Honor, I'm going to have to object for outside the scope of the record.
Mr. Capitan, any response?
Well, Your Honor, I think this is all on the record.
What part is outside the scope, Ms. Jacobs?
The part regarding her psychiatric medications is incorrect statement of the record. I would like counsel to refer to citations to the record should he continue to cite to or to reference it.
Your Honor, this is the very problem I have. Unfortunately, my defense witnesses aren't in this. Mrs. P, if you look at 126 through 127, she talks that she was on psychiatric medication, and then she stopped taking her medication.
Those are the transcript citations you're making?
Yes, Your Honor.
Okay, give me a moment. Ms. Milgren, if we could go off the record for a minute while I pull that up.
Yes, Your Honor.
No, I hope this isn't counting against my 15 minutes.
No, we've paused, sir. We're off the record.
Thank you.
So I know the panel members were given a full copy of the administrative record, but I have not been provided it. So Ms. Jacobs, do you have it in front of you?
What, Your Honor, if the panel members were given a full copy of the administrative record, I wasn't provided with a copy of that. Like I said, the last two, well, the defense's case wasn't provided, and Detective Garcia's testimony is missing pages.
Okay, so let's go ahead and address that. Ms. Milgren, if we could please go back on the record.
Yes, Your Honor.
And thank you. And again, this is not part of the 15. This is not part of the opening statement that Mr. Capitan was given. But I guess my confusion, Mr. Capitan, is when I look at the notice that you received and how to request oral argument before the board. There's instruction there to order a copy of the transcript, to contact Diamond reporters, et cetera. So did you contact Diamond reporters and they did not provide you with the full 7 days of transcripts, or did you believe it was Ms. Jacobs' responsibility to, or the board's responsibility to provide you with the full set of transcripts?
You know, I've got the transcripts, but we were given a copy of the board's, what it obtained as the record for this board hearing review. And that does not contain my transcripts. And I pointed that out in my written argument.
Okay, maybe I'm misunderstanding you, sir. I thought you said you did not see what the board panel members were provided, but now you're telling me that you know they were not provided the last 2 days of the hearing.
Well, no, Your Honor, there's an underlying transcript from the case itself.
Correct.
And you know, I consider this like an appeal, basically, from the law. The record of the underlying case is supposed to be forwarded to the board, and the board forwarded that to me. And what I got forwarded to me does not include the defense's case and does not include 34 pages, I believe it is, of Detective Garcia's case. I pointed that out. And frankly, I was waiting for someone to call me from the board and say, oh yeah, that's an error, we're going to correct that. But I never got that. And the AG has put in her brief testimony from the final 2 days that were not part of the record.
Okay, Ms. Jacobs, would you like to respond?
Yes, Your Honor. We did receive a complete record from the board on January 10th, 2022, wherein the board provided a link giving us access to all of the hearing transcripts, as the Attorney General's office did receive those transcripts directly from the board. Obviously, the board's in receipt of them.
And were you aware of Mr. Capitan's assertion that he had not received a full copy of the administrative record, or was unable to access what had been provided to the board?
Mr. Capitan did make that argument in his closing argument. However, it was only regarding, I believe, 1 day of transcripts. And that, I believe, was submitted to the board on January 24th in his written argument.
I've got the link that was sent to me, and right here in front of me are the two, I went and absorbed the costs and had them all printed out to make sure that I wasn't missing something when I reviewed this. And sure enough, there are, the defense's case is excluded from these transcripts. And that's why I raised it.
Your Honor, this is
Yes.
Michelle Angus, Board Counsel. I don't know if you would like to hear from me on this. I was just
I
looking.
would.
So obviously, I can't speak to what counsel did or did not receive, but I was just reviewing the administrative record that the board members were provided with, and it does appear to be complete. It does include the testimony of the detective. And then I also went back to look at the referenced testimony about the prescription medication. And there on page 126 of the first volume, there is of the transcript, there is a reference to a line of questioning about.
I'm sorry, Miss Angus, we cut out there a minute. Your last sentence, if you could say it again.
Sure. I was just saying that on page 126, there is reference to a line of questioning concerning whether Ms. P had ever taken medications for a mental condition, but there is no testimony, at least through pages 126 through 128, concerning that she had stopped taking them.
Okay.
That's in a different location. And Your Honor, I have no problem believing the board received the entire transcript. What I'm talking about is what we were given as the official record does not include those documents.
Well, but you have copies of transcript from days 6 and 7, which you said is the defense case, correct?
Absolutely, I do. But I also have a notice from the board that says I cannot go outside the record. And the record doesn't include them. That's why I brought first of all, a motion for clarification to find out just exactly what we were doing. And I filed in my written statement that we did not have those in the record.
So who did you file the motion for clarification with? I don't have it in my file here. Did you file it with the board directly, or did you file it with OAH?
I filed it through OAH because at that time that's who we were told to file it with. I believe it was.
Yeah, I have nothing in our in the OAH file. There is nothing there. I have the court reporter sheet. I have the request to set notice of hearing, and I have the petition packet, which basically says where we're going to be, and it has the underlying proposed decision. So if you filed a motion, it was not received by our office. I don't know if Ms. Jacobs received it or filed in opposition to it, but I don't have it before me.
I was provided, and I've got it in the other room, Your Honor. I was provided with a response, and it was said that it came from the board's attorney.
Okay. Well, I think my concern here, Mr. Capitan, is that Ms. Jacobs and Ms. Angus have both represented that when they're clicking the link, the full record is there, all 7 days, including the 34 pages of Detective Garcia's testimony. So I can't access the link is not provided to me, and it's not something that I can access to verify. But the board does have the full transcript, as does Ms. Jacobs. So they've been able to consider it, and you have it with you. So that representation has been made that those records are part of the administrative record and something considered by the board. So I don't see it as a denial of due process to move forward with today's oral argument.
No, that's fine. I'll preserve the link itself.
Okay.
Hey, Jeff, may I ask a question?
Yes.
Staff. Has that link been updated since it was initially uploaded?
Ms. Angus, ask if you can answer that question.
Sure. I can do my best. So I received the same links that the board members received, and there are 2 volumes to the Vang administrative record. So there were 2 different links that you have to click on, if that helps.
Do you know if the second volume is the part that is it just include the 2 last days of hearing, which I'm assuming is also part of the 34 pages of Detective Garcia's testimony?
I can't at this moment tell you if it's just that, but the second volume is where the detective's testimony is located, and it is quite lengthy.
Hey, I guess maybe we asked the question. Once the link was initially posted, did you update it or change it at any point in time?
I wouldn't do that. As I said, I received the same link that the board members receive, which comes from medical board staff. And as far as I know, they do not tamper with it.
Thank you.
In Your Honor, in regard to Detective Garcia, I got his testimony, and if you look at bait stamp page 945, the transcript page is 73, and then it goes to page 34.
It goes, I'm sorry, it goes from page 73 to page 34?
Correct.
That's backward?
No, I figured it out later. There's about, I forgot how many pages are missing, and it goes to another transcript.
Okay, I guess
I'm looking at that now, Your Honor.
I'm sorry?
I'm trying to look at that right now. It's a little bit difficult to manipulate, so if you could bear with me.
Okay.
Yeah, here, Your Honor, on mine, it's bait stamped Exhibit 51000945, and the page is 73. Then when you go to Exhibit 51001174, and it's page 34, so it's all off.
Your Honor, I am not seeing what he is saying. I'm not doubting what he's saying. I'm just not seeing it. So I don't know if he's received something different.
It's on
May I ask a question?
Yes.
May I ask a question? Our documents aren't bait stamped, so I don't know what he's looking at.
Okay.
Well, and see, that's my, I'm sorry, but that's my real concern. I mean, we all should have the very same record. And I've got bait stamps, and mine's Exhibit 51, bait stamp 000945. And that's Detective Garcia, page 73. The next bait stamp jumps to 1174, and it's page 34.
Okay.
Hold on,
Yes.
Your Honor. I got that said. I'm just now at page 73. And in volume 2, the transcript is bait stamped as Exhibit 51. On page 73, the bait stamp number is 000612. And the next page I have is page 74, 000613.
That's not what mine has.
So, I mean, in the bait stamp numbers, I just want to clarify, are these the bait stamps that the case lines did during the hearing, or is the medical board, because these include the transcripts, the medical board is separately bait stamped the administrative record? Is that correct?
I could not answer that. If Ms. Ortman's on the line, she could probably answer that for us.
Okay.
No, we didn't.
Michelle, could you tell me the page number you're looking at so I can get to the same page number?
So it's volume 2, and it is page 699 out of 2,356 pages. Oh, actually, that's page 80. Sorry.
This is Ms.
Page
Ortman.
three.
I'm the panel analyst here. Ms. Angus asked about the bait stamping and about the record. And we don't bait stamp the record. What comes to us, either the transcript or the exhibits come as they are, and we just compile that information for the panel. Also, the SUBA, the attorney for respondent, gets a different package than the panel gets, and only in that we do not provide transcripts to respondent. It is the respondent's or the respondent's attorney's responsibility to order the transcripts themselves. The only difference in what the panel and our attorney gets is that we order the transcripts from them. Otherwise, the links are created the same, all of the same documents go into them. And then those documents are shared to the different places they need to go. And I did verify that the proper link and the proper materials were there in the box for respondent's attorney.
And I'm telling you, the SUBA link that she just described is what I printed out because I was told that that was the record of this hearing. And mine goes from 9:45 to 11:74, and a good portion of Detective Garcia is missing, and none of that included my defense. And I specifically asked, were there any more records? And I've got an email that said no, there are no other documents. So yeah, and I don't want to belabor this point. It is what it is, and I made my record in that regard. I'd like to address the allegations.
Okay, so we'll resume back to your opening statement, and your objection is noted for the record. I mean, I'm not ready to rule on it at this time because, like I said, I'm not seeing the same thing you're seeing, and I don't know what the board has or accept the representations of Ms. Angus and Ms. Ortman as to what the board was provided. But it's difficult for me to, and I accept your representation that you received something different or it has different numbers than what Ms. Jacobs or Ms. Angus has referenced. But it does appear that the board received a complete administrative record, including all 7 days of transcript and all testimony that was received, and that you have access to that and are able to address that in your oral argument. So we will go ahead and proceed. I'm going to restart your 15 minutes because much of that was part of your objection. So your 15 minutes, sir, begins now.
Okay. Your Honor, when Ms. P went in, Ms. P also, in addition to the other, I think, emotional problems she had, I'll go from there. She had prior breast and gynecological examinations. And the reason why that was important is to see how she reacted to these alleged breast and gynecological examinations that she's alleging happened in this case. As far as the alleged incident, she went in and there was a Nancy Vang and a Nali Mua there. She described Nali Mua as doing the intake, and it was actually Nancy Vang. And that's important because it colored the way the officers examined these people later. When she filed the $3 million lawsuit, she, under oath, under penalty of perjury, said it was Mel Lowe who did the intake on her and took her vitals. Mel Lowe wasn't even at the location at that date. She ended up suing Mel Lowe, but Mel Lowe wasn't even there on the day that Ms. P was present. In regard to who raised the STD issue, Ms. P said that Dr. Vang asked her if she could have an STD, and it was kind of like an entree into doing these sexually explicit examinations, the gynecological and breast exam. Nancy Vang, the nurse, said, no, it was Miss P that raised that issue when she first came in. She said she was concerned about an STD and she wanted to be tested. We showed that it was approximately, I think, 4 months prior to this incident, Ms. P went into another doctor and asked for an STD test. Approximately 4 months after our incident, she went into a doctor and asked for an STD test. And that kind of gives you an indication of who was more accurate as to who asked for the STD. It was Ms. P that went in there. Dr. Vang did not ask her if she had an STD as an entree to do these examinations. She raised the issue. When you look at the allegations she raised, they make no sense. She was taken into room number 3, which is directly across the hallway from the office where all the workers sit. There were 2 of them there that day, including Dr. Vang. There was another patient in another room. Ms. P had indicated that she heard a baby crying in the other room. The woman confirms that there was a baby in that room. So it wasn't like this was a soundproof room. When you go to the breast examination, I'm not even going to go through all the contradictory statements she made about all of this incident. Judge Brown very clearly points it out. But what she describes is a violent assault. She says that Dr. Vang forcefully took her shirt and her bra and pulled it up. And as he's doing that, she's holding it down, she said, trying to prevent him from doing that. And she says in a loud voice, no, no, no. And she keeps repeating that. In testimony, she said, well, it was a quiet voice. But luckily, we have her on tape telling the police how she said it. And she was very forceful. And she said that he actually forced it way up. And there was an issue in the testimony of what force was. But she very clearly describes how she had to physically try to keep it down. He then grabbed her breasts with both hands and started pinching them. And then twisted her nipples or pinched her nipples so hard that she was afraid it was going to damage her surgically repaired breasts. Okay. Despite all that, she said, no, it was a normal examination. She had no marks on her breast, no bruising, no redness. There was no damage to her breast. They took pictures of it that night and they found nothing on it. She admitted that there was no damage to her breast, but she says it was a normal examination. Even though this was so painful, she thought it was going to damage her breast. There was DNA tests done, and Detective Garcia had to come in now, even though he's not an expert in DNA, and say, well, hand sanitizer could prevent DNA from transferring onto her breasts. Because what we found was that there was no DNA of Dr. Vang on her breasts. Luckily, we kept fighting for the DNA because it was over 2 years after they took the DNA that we received it in a criminal case that's pending. Okay. That DNA showed that there were 3 other men's DNA on Ms. P's breasts. Judge Brown found that very telling too, and I think she was right in doing that. You know, I don't know who the other 3 men were, and I don't care, but it shows that DNA transfer was there. In regard to the vaginal examination, it's even more egregious. She describes that Dr. Vang came in after he did this to her breasts, after he pinched her so hard she thought they would be damaged, and says, you know, I got to check you down low, basically, and grabs her pants and starts pulling them down. She then grabs her pants and forcefully is pulling them up, saying, no, 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 what are you doing? Things like that. Somehow, Dr. Vang, even though she never leaves the exam table, is able to pull her pants all the way down and pull them off. She gave different statements to the police officers, but she describes a struggle in which she's trying to hold her pants up and squeeze her legs together to prevent him from pulling down her pants and her underwear. At some point, and pardon the French, but this is a term she used, she alleges that Dr. Vang finger banged her. Okay? And up to that point, her statement was everything was normal. This was a normal examination up to the point of finger banging. And at that point, her only concern was that she may have an STD. Okay. You have a woman who was forcefully had her breasts assaulted, basically, was forcefully had her pants and underwear pulled down, and she testified that she thought it was all normal. When asked why she let this happen, she made a variety of excuses to the police officers and through testimony. At one point, she said that no woman wants a man to see her underwear. She said that she also thought because she had no insurance and she was not dressed and looked like she could not speak English, that's why Dr. Vang took advantage of her. Well, it makes absolutely no sense because this is basically a Medi-Cal clinic. Everybody there has no insurance. If you look at the videotapes of Mrs. P, she was very well dressed. She was primping throughout before she went into the room. You could see her on video fixing her hair, taking pictures of herself. And she spoke English to Dr. Vang, even though a lot of people who go there do not speak English. So she had all these excuses as to why she allowed this to happen. And Judge Brown rightfully found that this just wasn't credible. After the alleged incident, the AG alleges that Judge Brown said that the report wasn't filed, or that Ms. P didn't report it in a timely fashion. I can't find that in Judge Brown's statement, but more importantly is what we discovered during the testimony. Ms. P, we found out for the first time, the first person she called upon leaving the clinic was her ex-boyfriend. And her ex-boyfriend hung up on her the first time, and after she told him the story of what she says occurred, hung up on her again. She then called her friend Monica, and Monica is a mandatory reporter. She's some kind of clinician. And Monica's advice was for her to go home, take a bath, and have a glass of wine. It wasn't until she went to her ex-husband's house that he called the police. So the very first two people that she trusted most basically either hung up on her or told her to go home and have a glass of wine. When reviewing the AG's argument, I could critique almost every line, but I'm just going to go through the major portions. Initially, in regard to the pretext call, Mrs. P made a call to Dr. Vang, and the AG has described that as a confession by Dr. Vang. And contrary to being a confession, it's an absolution of Dr. Vang. Records show that when we first received a call from Mrs. P and left a message. Dr. Vang then went to his computer to look up her file. And one's got to question, why would a man who allegedly sexually assaulted this woman go look up her file to try to recollect who she was? If he had sexually assaulted her, you'd think he would know. He went to her file, looked it up. They finally got in contact with each other. And when he talks to her, you also have to understand the context of when she called. She called when he was at work at another clinic that he works at. He had a patient in the room with him, as he alludes to in his phone call when he tells her, I've got to go, I have a patient. When she asks him about the vaginal exam, he keeps saying, when I push down on your stomach, because he was checking her for a pelvic inflammatory disease or a urinary tract infection, which she had gone in there for. Every time she brings up vagina, he says, when I push down on your stomach. So he very clearly was denying ever doing that. He gives her sound legal medical advice, asked her if she's following through on the prescriptions, asked her if she went and got her blood work like she was supposed to, and she hadn't yet. So he urges her to go do that and tells her to come back in and they'll do another urine test on her if she's still having problems. And then he hangs up afterwards when he has a patient, when his patient he has to go to. In regard to the female staff member, the AG points out about the female staff member, which she fails to disclose, as I said earlier, is Ms. P wrongfully identified the female staff member who took her vitals. And why that was important is because it bastardized the rest of this investigation. Detective Garcia believed that it was Nali Mua that took her vitals. Nali Mua did not take Ms. P's vitals. She's just the intake receptionist. Nancy Vang took did the vitals and did the nursing type of procedures. The reason why that was important is because when they talked to these two ladies described what they did, and Detective Garcia didn't believe him. He thought they were trying to protect Dr. Vang. He finally had to admit in his testimony that he was completely wrong, that it was in fact Nancy Vang that did the intake of Mrs. P, and that what she had told him was correct. It bleeds over into Mel Lowe. Mel Lowe, when they executed a search warrant out at the scene, Detective Garcia said she was being difficult and being evasive. And once again, he felt that she was trying to protect Dr. Vang. Mel Lowe was concerned because she has HIPAA requirements, and she has never been through anything like this before, where there was like 12 officers came in and raided their office, and she had HIPAA concerns. When we got the records, there were literally hundreds of HIPAA violations. They gave us the names, the officers, when they confiscated the records, got the names of all the patients, what they were there being treated for, their addresses, their phone numbers, their insurance information, all private information that was supposed to not be taken. And Detective Garcia admitted that. Okay, but yet he was blaming Mel Lowe because she was concerned about what her legal obligations were. In regard to Dr. Erickson's conclusions, the AG points out that Dr. Erickson found that Dr. Vang did violate the standard of care in regard to the vaginal and breast exams. What they forgot to point out, though, is that Dr. Erickson was charged with assuming that all these examinations took place. He could not do an independent review of whether they occurred. He had to assume they took place. And as I told Judge Brown, Judge, I'll stipulate that if he sexually assaulted this woman, then that's a violation of your standard of care. We don't need an expert here for that. What Dr. Erickson did testify to, though, is that if these sexual examinations didn't take place, then there was no violation to the standard of care. So it all was dependent on the factual determination of whether these sexual examinations took place. And Judge Brown found that there was evidence, and I would submit substantial evidence, that they did not take place. Detective Erickson, though, I did have some trouble with him. At one point, he found, even though he wasn't supposed to make value judgments on the credibility of witnesses, he found that Dr. Vang wasn't truthful in his statement to the medical board's investigator because he had lied about something. What I was able to show Detective Erickson is that he was absolutely wrong in his readings of it. I think it had to do with Dr. Vang saying he saw one type of patient at one clinic and not one at the other clinic. And
Mr. Capitan, you have 1 minute remaining.
And he got that wrong. In regard to the records being changed, Detective Garcia had no understanding how Office Ally worked. It was the defense that brought in the creator to Office Ally, Jay Wu, and Jay Wu explained how Office Ally worked and that there was nothing changed in these records. They said that Dr. Vang entered this information in the computer in his normal course of business and scope of business. If you look at all the other patients he had that day, he entered their records the very same way. The AG said that he uncommonly went into her room more than once, and that's completely false. That's not what it says. Dr. Nancy Vang very clearly, she's not related to Dr. Vang, by the way, very clearly explained how he would jump back and forth to room, and if he had to see a patient more than once because they had testing done, he'd go back in. So there was nothing out of the ordinary in this case.
And Mr. Capitan, your time has expired.
Yes, yeah, thank you, Judge.
Thank you. Ms. Jacobs, are you there?
Yes,
Ms. Jacobs?
can you hear
Okay,
me?
I can. Your time begins now.
Thank you, Your Honor, and esteemed members of the board. The proposed penalty here must be modified, and revocation is the only level of discipline sufficient to protect the public. Revocation is required because the rejected proposed decision and order is archaic in that it blames the patient victim for the sexual assault, is illogical, conflicting, and does not accurately reflect the evidence and the testimony. Moreover, respondent is unrepentant, and there are no mitigating factors to warrant anything other than revocation. Consistent with the board's primary mandate, public protection is always paramount. Here, a paradigm shift away from blaming the victim is mandated. Society has made such a shift away from blaming these victims. However, this proposed decision and order is antiquated in that it does exactly that. It blames the victim. It is simply unacceptable for an administrative law judge or ALJ to determine that a female patient is not credible because she allowed herself to become a victim to an improper vaginal and breast exam. It is appalling that the proposed decision states that the patient was not credible because she was a 28-year-old mother who, quote, was not a stranger to pelvic examinations, end quote, and thus, quote, should have known to immediately cease the examination and call for help, end quote, at page 41. It ignores the evidence that the patient was seeking medical care for a painful urinary tract infection, the first UTI that she had ever had. Thus, she had never had any experience with UTI examinations or treatment. That was her first time. More importantly, it is disturbing that the proposed decision attempts to say that the pelvic examination did not happen, while also blaming the patient for allowing it to happen and finding the patient not credible because she allowed it to happen. It cannot stand for an ALJ to find that a patient victim who is uncomfortable reliving a sexual assault that occurred 4 years prior is, quote, coerced, end quote, into testifying and not credible because she doesn't appear to want to testify, quote, despite finally having the opportunity to tell her story to the court, end quote. And to note that the victim was not, quote, resentful, angry, vindictive, or hateful, despite her serious allegations of sexual assault, end quote, at page 36. It is unacceptable to think that a victim of sexual misconduct should be appreciative and eager to testify, while she also relives the assault. But she should also be angry and hateful towards respondent at the same time. How can a victim be eager to be cross-examined about the custody of her children, prior contraceptive use, prior testing and treatment for STDs, and prior breast augmentation, while also dealing with respondents' attempts to admit full frontal naked photographs of her from her breast augmentation medical records? That's within complainant's pre-hearing motion regarding exclusion of exhibits filed on February 10th, 2021. The patient endured all of this while on the witness stand for 2 days, yet the ALJ thought that she should appreciate, quote, the opportunity to tell her story, end quote. Such determinations discredit the hard-fought evolution of patient rights victims and the expectation for professional conduct in physician-patient encounters. It fails to contemplate the trauma caused by sexual misconduct and the lasting adverse effects on victims. This proposed decision requires a long, hard look at what training on sexual assault and sexual misconduct cases is provided or not provided to the state of California administrative law judges. Here, the patient was brave, articulate, convincing, emotional, and painfully honest about the improper breast and vaginal exam she was subjected to at an urgent care clinic for children in 2017. She described that improper vaginal exam as finger banging. The breast exam consisted of respondent squeezing her nipples to, quote, check for discharge in an incredibly painful manner. For example, the patient was painfully honest in describing the fact that she was embarrassed that respondent would see her vaginal discharge on her thong because she hadn't showered while he was pulling her pants down. Moreover, the evidence supports her testimony. Respondent's own medical records reflect that he performed an unwarranted and improper breast exam in which he noted that he, quote, found no discharge, end quote, Exhibit 23 at page 399. And his medical record stated, quote, vaginal discharge and redness at private part, question mark, Exhibit 23 at page 399. Detective Garcia testified that during his execution of the search warrant, while trying to get the patient's medical records, respondent's girlfriend, Melissa Lowe, whom he stated owned the clinic, was uncooperative, quote, adversarial, end quote. She made him wait 40 minutes, making Detective Garcia concerned that they were altering the records. During the same time, respondent was accessing and changing those electronic medical records. Moreover, Detective Garcia did testify that touch DNA of the patient's breasts were unlikely to get proper DNA results, especially when the party touching washes his hands or uses hand sanitizer right before. During the pretext phone call recorded by authorities, respondent never denied the patient's comments about him checking her vagina and digitally penetrating her. Further, it is confounding that the ALJ found respondent's failure to stock adult paper gowns strong evidence that he did not perform pelvic exams when respondent told investigators that 40% of his patients were adults. Exhibit 18 at page 261 and 275. How can this proposed decision find respondent's girlfriend was, quote, clearly displeased, end quote, at having to testify, and, quote, evasive in her answers at times, end quote, particularly about her ownership of the clinic, yet inexplicably in the proposed decision find her not only to be, quote, credible, but also, quote, believable, end quote. How can this proposed decision find respondent credible, yet ignore his admissions of the vaginal exam in his pretext phone call, wherein he never denies performing a vaginal exam and even offers to have his office staff watch the patient's children so she can come back and get a follow-up vaginal exam. Exhibit 15 at page 149. And how can it further find respondent credible, yet determine there is insufficient evidence of corporate practice of medicine, despite respondent's numerous admissions of it to board investigators and Detective Garcia? Such illogical conclusions are rampant in this proposed decision and order. In respondent's written argument, he incorrectly claims that this board must uphold and defer credibility determinations made by the ALJ, and that this board is not allowed to review the evidence. Respondent is incorrect. The ALJ's proposed decision is not a lower court. An administrative matter is before a board, not an appellate or higher court. Such factual findings were merely proposed by the ALJ. They were not binding factual findings. Moreover, as this board clearly articulated in its order issued on November 30th, 2021, the ALJ's proposed decision has already been rejected pursuant to Government Code Section 11517, subdivision C is in cat, 2, E is in elephant. That is why we are here today. In that order, the board rejected the proposed decision and informed both parties that a panel of the board would, quote, decide the case upon the record, end quote, along with any argument submitted by counsel. For respondent to argue that the board must adopt what has already been rejected is fundamentally incorrect and statutorily inopposite. In addition, respondent argues that he has not had an opportunity to be heard. He has had an opportunity to be heard twice, both written and orally. The statute mandates only one. The record is complete, as we previously discussed. In closing, it is offensive for an evidentiary determination of a patient's veracity to rest upon what she should have done, or how she should have known better, or to question why she allowed a sexual assault upon her body to occur under the guise of physician treatment. Thank you.
Thank you, Ms. Jacobs. Mr. Capitan, your 5-minute closing argument begins now.
Yes, Your Honor. First of all, in regard to the victim, the AG's office thought it was cute in that they didn't file a sexual assault type of charges against Dr. Vang. And therefore they said that's all off limits. We can't argue about that. And Judge Brown very directly said, no, that's the whole issue of whether these things actually occurred. And what's frustrating is when you challenge a alleged victim's statement, you're accused them of attacking the victim and things like that. Judge Brown went through a very detailed statement as to why she didn't believe Ms. P. And to cherry pick various portions and say, oh, this is offensive, that's offensive, you have to look at it in the totality of the circumstances. And that's what she did. And now they want the board, who never had an opportunity to even see Mrs. P testify, make the decision as to her credibility. The breast exam, no discharge, and vaginal discharge, where they said that's in his record, Ms. P stated those things in the pretext call. That's where that information came from. You have to look at this case in its entire context and the totality, and that's what's frustrating. I've got 15 minutes and 5 minutes to talk about something that went over a 7-day period of time. In regard to gowns, Judge Brown didn't say that's strong evidence that this didn't occur. What she was saying is that's strong evidence that they don't do those type of exams at the clinic because they don't carry those type of gowns. One time, Dr. Vang looked at the upper buttocks, if you look at the actual record of a woman, because she had an abscess on it. And he got his nurse to do a chaperone him at that time. So he knew what to do. I don't know how many times we have to say this. Judge Brown did not believe Mrs. P. And I'm sorry if that sounds offensive, but she actually heard the testimony. Several people heard the testimony. And she did not, she concluded that this did not occur. As far as showing pictures of Mrs. P, the ironic thing is a year prior when she had a breast exam, Mrs. P did not allow them to use her pictures. 4 months after, I think it was, she had her breasts redone, and she allowed the plastic surgeon to take naked pictures of her so he could use in her advertisement. This is at the same time she's saying she was so distraught over this that she couldn't work, but she lets someone take naked pictures of her to use as advertisement. I don't know what that means, but I think it goes to her credibility, and it is significant. And evidently, Judge Brown found the same thing. And finally, in regard to the practice of medicine, I would point out Dr. Vang has an unblemished record. I think he's over 17 years. He's seen thousands of patients. He has never had one complaint against him prior to this occasion. After this, it was publicized. And even though it was publicized, nobody's come forward and said, oh yeah, he did something like that to me. We brought in a patient who was present that day, who has gone to him for her daughter and for herself, and said, Dr. Vang has been nothing but professional. She thinks he's a great doctor. He tried to give Mel Lowe the business because it wasn't making enough money to pay them back. Unfortunately, they didn't do it legally. And that was our argument, that even though he tried, he didn't do it legally. And in an attempt, you have to have the specific intent to violate the law. There was no intent here. And more importantly, his intent was a good motive. He was trying to make sure the rent was paid and that Miss Lowe was paid back for the loan that she gave him to open the clinic. This was a clinic that was targeted for low-income individuals, mostly children. He was doing it. He was working there for free. And
1 minute, Mr. Capitan.
You can crucify the guy over that, but he did everything he was supposed to do. Here's a doctor with an unblemished record, and a woman came in and made these allegations against him, and the judge who actually got to hear that testimony did not believe her. And I think that's pretty strong. And I don't think a man's career should be ruined. And I don't think the public is benefited by taking a good doctor off the streets who is targeting low-income people for his clinic. Finally, Your Honor, I don't mean to attack Mrs. P, but I have a job to do, and it's to try to test under the crucible of cross-examination of whether her story made any sense. And it did not. And unfortunately, that is not attacking a person. That is our system. And the Judge Brown found that it did not make any sense, and that's why she reached the conclusions that she did. Thank you very much, y'all.
Thank you. Ms. Jacobs, you have 5 minutes for your closing argument beginning now.
Thank you. The relationship between a physician and a patient is inherently unbalanced. Physicians and surgeons have authority through their education, training, experience, and above all, their medical board licensure. As such, physicians hold a position of power and authority to diagnose and treat all patients, to have a knowledge of intimate details of their patients' medical histories, and most importantly, to have access to view and examine any part of the human body of any patient, either child or adult. This physician-patient relationship is built upon trust. That involves a patient being able to have a confident belief in the moral character and competence of physicians. When there is a violation of that relationship through sexual misconduct, such behavior and actions can have a profound, enduring, and traumatic impact on the victim, along with the public at large, and even the medical profession as a whole. Given the extreme vulnerability of respondents' target patient population of children, and that the sexual misconduct was not the only wrong occurring here. He was also engaged in the corporate practice of medicine, incompetence, and tampering with medical records during an investigation. Allowing probation is not enough to protect us. Revocation is required. Contrary to the ALJ's assumptions, it was not the patient's burden to fight and kick and scream and protect herself during an improper vaginal or breast exam. However, it is now this board's burden to protect the rest of us from him.
Thank you, Ms. Jacobs. At this time, I'll poll the panel to see if there are any questions for the council. Dr. Thorpe, do you have any questions?
I do have questions, but I would just reserve the right to ask them at the end of the rest of the panel's questions.
Okay, I'll circle back. Ms. Campoverde, do you have any questions?
I do. First of all, listening to Mr. Capitan's statements, many of which I find extremely offensive, the references to the victim primping, fixing her hair, allowing naked pictures to be taken of her, multiple men's DNA being found on her, STD checks, and talking about how many she had to have. I mean, the tone of what's been presented is very concerning to me. I've heard a lot of focus on why this woman's character should be doubted, not a lot of focus on whether or not the actions of the doctor were proper. I have heard nothing about how he handled the procedure there was an admission to there having been a vaginal exam. Was there a chaperone in the room? Should he even be, according to what it is that I've read, he shouldn't even be performing these types of exams, or he says that he doesn't. Also, we haven't talked about the circumstances of which he was working there. We've talked about the victim's divorce and emotional problems. We haven't talked about the fact that The doctor recently went through a divorce, could not afford to run this clinic. Therefore, he transferred it to his girlfriend. When he was working at this clinic, he did not earn a salary. All of his work there was volunteer. So again, it feels very one-sided, what we've heard. If you'd like to speak to some of the things that I talked about this exam and how it did proceed in a way that you consider to be in line with proper standard of care, I would love to hear that.
Yes, ma'am, absolutely, I would. First of all, I apologize if it sounds like I'm being rough on Mrs. P. I've got 15 minutes to condense 7 days of testimony here today. I'm a pro at what I do, okay? I don't ask these questions for fun. I don't ask the questions to embarrass people. Every question I ask, there's a reason for it. When I said primping, if you look at the video, Mrs. P, when she goes in there, is dressed nice. Her hair's nice. She's fixing her hair. She's taking pictures of herself. She's on her computer, on her phone. The reason why that's important is because she then makes the excuse later that the reason why she thought she was attacked was because she didn't look well and she hadn't showered. And so it's not the issue of her saying that she's primping. It's the issue of that goes to her credibility. She looked very nice. She looked very professional. This is a medical clinic, so a lot of the people that come in there are very rough. She looked very nice. She had nice clothes, a nice purse. So that's why that was relevant. The DNA testing, the 3 men on it, that's relevant because first of all, you got to understand, we've been at this now for, I think, 3 years. There's a criminal lawsuit that's pending at the same time of this. We were never, ever given the DNA results. All right. And, you know, if you're offended, you got to see how I feel. I've got a man who's fighting for his life, his livelihood, and basically his life. And they have DNA results and they don't provide them to us. And we ask in the criminal court, we need them, we need them. Literally, I think it was a week or two before this hearing, we got those DNA results. I didn't take the DNA, the police officers took the DNA, and they took the DNA because he was accused of grabbing this woman's breasts and pinching them so hard she thought they were going to be damaged. And yet there was no DNA on those, on her, from him. They had to figure out something. And once again, I didn't do the DNA, they did it. And they said, well, if you use antiseptic, it could get rid of the DNA. Okay, well, there was 3 other people's DNA on there. Okay, and I had to point out there were men because she went to her friend's house. I want to make sure it's not other women who are saying, hey, let me check them, you know, make sure everything's okay. It was 3 other men. So you can get DNA transfers from one human to another human. This case was proof of it. There were 3 other DNA transfers. And the fact that there were men, if you find that offensive, I'm sorry, but that's just the facts that came out. The vaginal exam. The whole point is Judge Brown concluded, as I do, that there was no vaginal exam. He didn't conduct a vaginal exam. When she tried to get him to say in that pretext call, when you put your fingers in my vagina, he kept telling her, when I press down on your stomach. And Dr. Erickson admitted that that's the way you would check somebody for a UTI, which Ms. P went in there for. The thing that I'm frustrated by, you got to understand, I've got a wife, I got a mother. I'm not some, you know, beast that loves to beat up sexual assault victims. But first we got to decide whether she was the victim of these allegations. And there's a lot of evidence that shows she wasn't. In regard to the STD tests, the reason why that was important was because she said that Dr. Vang brought up the issue of STD so that it was like an entree for him to do these examinations. She very adamantly said he's the one who brought it up. Nancy Vang, the intake nurse, said, no, when we were in the vital rooms, she asked me to have an STD test. That's what brought it up. He didn't bring it up as an excuse to sexually assault her. She brought it up. And so I'm left with contradictory statements. Nancy Vang said she brought it up. Miss P said she brought it up, or Dr. Vang brought it up. And so I brought in the fact that 3 or 4 months earlier, Miss P asked her previous doctor for an STD test. 3 or 4 months after, she asked another doctor for an STD test. Well, that gives you kind of an indication of who was more likely that brought up this STD issue. Nancy Vang actually wrote that like 2 or 3 days. It's in the record. She wrote a declaration as to what she said occurred. And at that time, she said Mrs. P brought up the STD issue. So every question I asked her wasn't in an attempt to embarrass her, wasn't in an attempt to attack the victim. It's an attempt to determine whether what she is telling me is true or not. And I mean, if we are just to accept when a woman or even a man comes in and claims sexual assault that you cannot test the credibility of that, well then fine, take him out and shoot him today then, because it's already been decided. If we have to believe what Miss P said without being able to even ask her questions, relevant, critical questions as to this, then I got news for you. You guys could save a lot of money. We don't need these hearings. We don't need the underlying hearing. You just take him out and shoot him because we've already decided he's guilty. That underlying hearing, the whole purpose was to decide whether he did these things or not. And the Judge Brown, with a substantial amount of evidence, concluded he didn't. And to claim now that she is archaic and I'm archaic just because I don't believe Mrs. P, that's not fair. I mean, we have jobs to do and we did them and we do them the best of our ability. And I do them as fair as I can and I do them as honestly as I can. And I don't do it to hurt people or to attack her. I don't believe her. Judge Brown didn't believe her. And Judge Brown heard her testify and heard the evidence. And to cherry pick a couple things that Judge Brown said without putting it in context of everything that occurred is the same thing that just happened. Those questions I asked were for a reason, and they weren't to embarrass her and to make fun of her. They were there because she said something that contradicted that. And that's the best I can give you. And I'm sorry. And then final thing is Dr. Vang's divorce and that. Have at it. If the AG wants to ask him about that, we had 7 days worth of hearing. She could bring up all those issues. Okay. Dr. Vang cooperated with the medical board. He's now being criminally charged with something that can end him in prison for a long time. And because of that, I cannot have him testify now. I asked that this case be put over till after the criminal case. That was denied. So that's what we're left with. This poor man cannot defend himself as far as testifying because he's got to wait for the criminal case. Any good attorney would tell him that. And so we were left with cross-examining Miss P. And frankly, Miss P did a horrible job, and Judge Brown saw that. With that, I would submit that.
Thank you, Mr. Capitan. Any further questions, Ms. Campoverde?
No, thank you, Judge.
Thank you. Mr. Brooks, any questions?
No questions. Thank you.
Thank you. Dr. Heelser?
No questions. Thank you.
Thank you. Ms. Lawson?
Yes, Mr. Capitan, to say that I am offended by your presentation and by your response to Ms. Campoverde's questions is an understatement. I would, however, like to give you an opportunity to respond to the question that Ms. Campoverde just asked you, which is whether or not your client, who's sitting next to you, met the standard of care with respect to the examination he conducted.
Okay, well, and I mean this in all sincerity. I mean, I know you folks don't know me, but I am not sure what I've said that is so offensive. And I know that's going to make me sound like even a bigger ogre because I don't understand it. I've got a job to do, and my job was to determine whether these things actually happened. And so I question Ms. P with that in mind. Maybe you can help me, and I'm sincere too. What do you find about what I said so offensive, so that I can try to clear it up?
Sir, stick to responding to the question I just asked you if you're so inclined.
Oh, okay. I can give you what the board's expert said, and that's Dr. Erickson. And Dr. Erickson said that if the breast examination and the vaginal examination occurred, they violated the standard of care. And I'm going to go one better, and I've already said this. If the examinations, as Mrs. P described, occurred, you wasted your money hiring Dr. Erickson, because I would have stipulated that that violates the standard of care. If a doctor forcefully sexually assaults a woman by pulling off her top and bra and grabs her breasts in such a fashion that has no medical purpose, and then forcefully pulls a woman's pants down where she's fighting against them and pulls them out and then finger bangs her, as that woman said, I'll stipulate that that violates the standard of care. The issue was whether that occurred. And Dr. Erickson stated that if those examinations did not occur, then no standard of care was violated. And that is my position. I'm very concerned that we're putting the cart before the horse and jumping to the conclusion that these examinations occurred and then deciding what if that's right or not. The very first thing you got to decide is whether those examinations occurred. And you know, I mean,
sir, did your client examine this woman? Did an examination occur?
Yes.
Did that examination meet the standard of care?
The examination he did, yes, according to the board's expert, Dr. Erickson. If the examination didn't include the alleged vaginal exam and the alleged breast examination, then there was no violation of the standard of care.
And that's what you believe Dr. Erickson determined, because that's not what the judge's determination indicates.
Yes, it does.
I have no further questions.
But
Thank you. I'm going to circle back around. Dr. Thorpe, did you have any questions?
Yeah, I mean, this is a very, very troubling case, because I think it does, you know, it basically comes down to whether the patient victim, Mrs. P, is credible or not, and we don't have, you know, we don't have access to that information because we didn't get to observe the trial. It is very troubling to me that if it occurred as Mrs. P said, then clearly Dr. Vang was very inappropriate, and that's the challenge: is how do we determine, you know, who is actually, and the fact that Dr. Vang chooses not to be interviewed or not to take questions. I recognize the legality of it, the legal dilemma, but it puts us in a much more difficult place as well, because we don't really get to hear him, you know, give his side of the story, and even if we could, maybe that wouldn't even be appropriate, because we can't hear Mrs. P. It does come down to he said, she said, and I guess I'm making a statement, not making a question, but I guess the issue, I similarly had a number of problems with the ALJ's conclusions based on the record that we had. So I guess my question to Mr. Capitan is this. We're very sensitive about the differential in power between a physician and his client, his patient, whether it's a child or a woman or even another man, there's a differential in power. Abuse of that is very concerning. And so I guess my question is, well, I mean, basically what I hear you saying is that we should just depend on the ALJ to determine all of this conflicting evidence because she was there hearing the case. Is there anything else that you can give us that would give credibility to your client?
Yeah, yes, sir. First of all, it actually hurts to be accused of basically being a misogynist who doesn't care about women. You know, I've been married 30 years. I've never cheated on my wife. I was a good kid growing up. You know, I've got a job to do, and the job was to determine whether Mrs. P was telling the truth. And I brought in stuff that I thought was factually relevant to make that determination. I didn't do it for fun. I didn't do it to put this woman through anything else. At one point, I requested that the pictures be taken down because they were left up, and I know other people can watch this. And so I tried to be as respectful as I could. Dr. Vang, I requested that this be put over past this criminal case so that you could hear everything. They rejected that because there was such this, the public concern, you know, the public protection was so great. Well, the problem I had with that was it took them almost 2 years, I think it was, to even file this case against Dr. Vang. Okay, so the public concern for the public during those 2 years wasn't so great that the AG or the DA went out and said, let's do this right now. Okay, they took 2 years. After this came out, his practice was gone. I mean, it was publicized. Okay. So he wasn't practicing. So there was no reason why we couldn't put this over so we could get all this information and that you could listen to him testify. The other thing I could point out to you is, and this is what troubles me about this case, I don't know what happened in that room. I know what Judge Brown found, but I can't tell you 100% for sure one way or the other, but that's not my job. My job is to make them show by clear and convincing evidence, and they couldn't. All I know is Dr. Vang has no blemishes on his record. He's never been accused of anything like this before. He's never been accused of anything like this afterwards. You think that there would be at least somebody out there that said, hey, you know, this guy did something weird with me. Everyone we called and we brought one in, he's a great doctor. He's very respectful. All of his staff that the police interviewed said he's a great doctor, very respectful. The police never went out and looked for other people. It's just troubling that to me that, you know, and I think you've got it right on the nose that Judge Brown saw Mrs. P testify and didn't believe her. And, you know, I don't know what to tell you folks, but that was her conclusion. You know, and to just say that Judge Brown's archaic and that I'm an ogre, that's not a response. I mean, we do our jobs and we try to do them sincerely. That was the conclusion of an independent judge. Okay, and she actually saw it. Dr. Vang has no history, nothing. He cooperated with the board, talked to them, but he had a criminal defense attorney at the time who advised him not to testify, which is absolutely standard practice in this sort of stuff. If you wanted to hear Dr. Vang, we could have put this over till after his criminal hearing. We were willing to do that. We begged to have that done so that he could do it. The other frustrating thing is he's got 3 different venues he's dealing with: the criminal court, this administrative court, and civil court. He doesn't have the funds, and that's why I brought a motion for clarification. I just can't go chasing down every rabbit hole. I've got to try to preserve his funds. So he's doing his best to fight these cases with the assets he had, you know, and I mean, it's just depressing when you represent somebody, you do a good job just to be told that, you know, you're a misogynist and you're appalling. And I mean, I'm 61 years old. I'm getting tired of it. I don't need this stuff anymore. I just feel, I try to do my job the best I can. We did a good job in the lower case. The judge did a good job. She wrote an excellent brief, and she found Mrs. P not credible. Now, you can take that for what it's worth. But to come in here now and say, we're going to overturn that when we've never even seen her, just because we're going to believe victims in all these cases, that's not fair. And if that's what we're going to do, then, like I said, you're all wasting your time. We don't even have to have these hearings anymore. I'm sorry I sound, you know, kind of combative, but, you know, it's hard to sit here and just be told that you're offensive and you're a misogynist. I mean, when you don't know me, you don't know my life and what I've done. It's just not fair. And that's what you're doing to this man. I'm sorry, folks.
Thank you, Mr. Capitan. Does anybody from the panel have any additional questions? Okay. Hearing none, then I think I know the answer to this question, but Dr. Vang, I do have to offer you an opportunity to address the panel. Would you like to do so?
No, I've instructed him not to give a statement.
Understood. Thank you. Then at this time, that does conclude oral argument in this matter. The record is closed. The case is submitted, and we can please go off the record. Thank you, everyone.
Thank you all.
Thank you.
Dr. Thorpe, I am going to ask if we could take a brief comfort break before we call the next case.
I think that makes sense. Well, which way? Reconvene in 10 minutes?
Sure. So that I have 10:43, so let's come back at 10:55. Does that work?
Sounds great. Thanks.
Okay. Thank you, everyone.
Judge King, are you okay if I check in the next participants while we're on the
Yes.
break? Okay. Thank you.
Yes, that would be great. Thank you.
Mr. Seamus, if you could confirm you can come off mute, and you should be able to start your video now. Let me know if you're there.
Yes, sir.
Great, thank you very much.
Can you hear me and see me? Oops, I'll get the video zoomed in so you can see. And then Dr. Zospah is also on, and I don't know if you want to let her in now, sir, or wait till the end till the panel has questions, whatever your pleasure.
I just did promote Dr. Zospah as well. Dr. Zospah, are you there? Hope I'm pronouncing that correctly.
Yes, I am.
Great, and you're also free to start video if you have a device that's equipped with a camera. And Miss Murphy, I just promoted you as well. If you could come off mute and let us know.
Good morning, everyone. Can you see and hear me? Oh, can you also see me now?
Video might be just starting up, but I don't see it quite yet. There we go.
Okay.
All right, now I see your video as well. Thank you very much.
Thank you.
All right, everyone's video looks good. Everyone's audio sounded good. So we'll just wait on Judge King and Dr. Thorpe to come back in and call the meeting back to order, okay? Thank you so much.
Thank you. I'm going to leave everything running and walk away for just a minute.
Very good.
Thank you.
Mr. Stevens, just because I can pick up some background audio, I'm going to go ahead and put you on mute now, okay? Feel free to unmute yourself when your turn.
Okay, we're unmuted, I think.
Yes, you are.
Okay, there we go. Thank you.
I see Judge King returning here, so when Dr. Thorpe's ready, you guys can get back to it. Thank you.
Thank you.
Okay, Sean, I'm back.
Very good, Dr. Thorpe. I see Judge King as well, so you guys are free to go on. We've checked in everybody for the next argument.
Thank you.
Is
Just give me
everybody, the rest
one
of the panel
moment.
ready to go?
Okay. Good morning, everyone. This is Judge King. Doctor, I want to just make sure I pronounce your last name correct. Is it Zospah or Zosa?
Zospah.
Zospah? Okay, thank you. Okay, Ms. Milgren, are you with us?
I am, Your Honor.
Okay, if we could please go back on the record. Good morning, everyone. We are on the record before the Medical Board of California in the matter of the accusation against Raelene D. Zospah, doctor. The board's case number is 800-2020-068444. OAH's case number is 2022-01-0243. Today's date is February 10, 2022. The time is approximately 10:50 in the morning, and this hearing is being conducted via video conference through the WebEx application. This is the date, time, and place set for oral argument in the notice of hearing for oral argument. My name is Tiffany King. I am an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over this matter. Prior to going on the record, the board members identified themselves and a quorum was established. At this time, if I could please take the appearance of counsel, beginning with the Deputy Attorney General.
Yes. Good morning, Your Honor. This is Hamza Murthy from the Deputy AG's office. Can you hear me?
I can, thank you.
And I just want to make one clarification, if I may, Your Honor. This is in the matter of the first amended statement of issues against Raelene D. Zospah, not accusations. Forgive me, Your Honor.
No, I appreciate that. I apologize for making that mistake. Thank you for clarifying that. Okay, Mr. Siemens, if you could state your appearance.
Yes, good morning, Your Honor, and good morning, panel members. My name is Stephen Siemens from Siemens & Associates, and I represent Dr. Zospah. And to my right is my paralegal, Kendall Bowers.
Okay, thank you, everyone. The board in this matter has issued an order of non-adoption of a proposed decision by an administrative law judge and is determined to hear the matter itself. The board has invited particular discussion of whether the proposed order should be modified. The following process and time limits will apply. Respondent will have 15 minutes to make an opening argument. The Deputy Attorney General will then be given 15 minutes to respond. Respondent will then have 5 minutes for a closing argument, and the Deputy Attorney General will be given 5 minutes for her closing argument. The time limits will be strictly enforced. I will give counsel a 1-minute warning so that you know how much time you have left, and then I will tell you if time has expired. The arguments shall be based on the existing record only and shall not exceed the scope of the record of admitted evidence. No new evidence can be heard. The panel members may ask questions of the parties to clarify any arguments, but they cannot ask any questions that would elicit new evidence. The administrative law judge and any panel member may ask a party to support their oral argument by citing to something specific in the record. At the end of oral arguments by counsel, I will offer the respondent an opportunity to address the panel regarding penalty. If she chooses to address the panel, she will be placed under oath first. After the oral arguments are over, the board will go into closed session to deliberate. The parties will not receive a decision today, but will receive something in the mail in the future. Again, please remember that all arguments must be based on the existing record, and also know that the panel members have already had the benefit of reading your briefs. So with that, Mr. Simas, I will turn it over to you, and your 15-minute time begins now.
Thank you, Your Honor, very much. And panel members, thank you for your time today. We had logged on earlier and watched some of the other cases, so we appreciate that you've been doing this for a while this morning. In our argument, which you have all read, we tried to lock down our citations to the record, and you know, we've pretty well organized our case. So my oral argument, I'm going to try to focus on a couple of other things. The brief starts with this being a case of first impression. I hate when people say that, because I don't always believe it, and it's colloquial and all of that, but I think this really is. I've been a healthcare lawyer for 31 years now and a former deputy attorney general, and this case took place at a very weird time during a pandemic, and the single biggest differentiating fact between this and the other 17 cases from 2016 to the present that the board has provided me under public records, where it's a statement of issues denial of a resident or trainee. The one unique factor in the administrative record that I've never seen before, and I believe the board has not, and ALJ Astle has agreed, is this is an applicant for medical licensure in California who practiced for 14 months under the supervision of a wound care physician in California very successfully, and based on evidence in the record, had an incredible success in wound care healing and patient outcomes based on national standards and statistics. I've not had a case where I have an applicant for a license who's actually practiced in California, because that makes no sense. I've had Montana and Ohio and all of that. So that's a unique fact, the evidence of which is in the record. In this case, Dr. Zospah got a training license, or based on her residency license in North Dakota. The California Emergency Medical Services, due to the pandemic and Governor Newsom's executive orders, granted her a temporary license in California. And that's unique and weird and pandemic related. And I know all of you in your conversations with people, when you're referring to things, you say, well, during normal times or during now, you can't even have a conversation. So because of that, this is a case where you have your mission to protect the public impacted by this particular fact, which is uncontroverted in the administrative record. The other statements of issues cases that the board has handled, especially from 2016 to the present, involve flat out license denial for things like dishonesty and things. A lot of residents who are mid-residency program they have probation in the new residency program, and they're allowed to finish. And then one of them, two of the cases I've had, they're mine since 2016 to the present. One of them involved a physician training authorization letter, and the other was a resident who got probation but was out of state and practicing in Michigan. So there is no case exactly like this where we have somebody who practiced in California. Dr. Zospah practiced for Dr. Marriott, who we will talk about a little bit, who is in the administrative record. We understand the mission of the board today in seeking non-adoption and wanting to clarify this, the order, and as Judge King said, we're supposed to focus on the penalty. The way we interpret that is, and would translate that, Does the board think that Dr. Zospah should get an unfettered license as the administrative law judge held, or should she have probation? And what terms of probation? Hence, the board is examining the case and the decision and all of that. Again, the board's mission is to protect the public. And I believe when you go into deliberation with your Department of Consumer Affairs counsel, you review the administrative record, which the board is mandated to do, and you look at the evidence. The problem is the ALJ, Judge Astle, didn't find any evidence to support probation. There's just no reason in the record to have put Dr. Zospah on probation. And that's still the case today. And we're going to go through that. The board legally, as your counsel will tell you, and I understand a couple of the board members are legal counsel too, and probably understand how writ petitions work and the Topanga case about administrative findings and all of that work. But findings of the board must be supported by evidence. And I'll get into the evidence, but under Government Code Section 11517, the non-adoption has to still have evidentiary findings. So the board can find what it wants, but it has to be based on evidence. And that's where I believe the board's struggle will be, fashioning terms of probation for Dr. Zospah. Ironically, in the oral argument, written brief, and in the administrative record, and in Dr. Zospah's testimony, which I encourage you to ask her about at the end, we asked the ALJ, hey, we're fine with probation if we need to. We've brought this up to the board throughout the entire duration of the underlying case. After non-adoption, our client has always been willing to have probation and asked for it. The ALJ rejected that and ordered no probation because there was no evidence to support it. So as we sit here today, Dr. Zospah is willing to have probation, but the problem is the record doesn't have support for that. The evidence in the case is like the other board statement of issues cases, a number of which the board has non-adopted since 2016. I can't imagine how the board regulates all kinds of residency programs throughout the United States and even international programs. They are not all created equal. So during my career practicing in healthcare law, I've seen great residency programs, I've seen terrible residency programs, and we represent residents against their programs quite a bit. So one of the big issues in this case is what's the evidence in the record? The only evidence and witness the board and the Deputy Attorney General offered was the testimony of Dr. Khatri. Dr. Khatri relied exclusively on reading documents from the University of North Dakota. That's it. He's never seen Dr. Zospah practice. He's never looked at anything outside of North Dakota. And his opinions are based exclusively on documents, not percipient observation. He is not a percipient witness. And as the attorneys present and attorneys who are panel members know, an expert witness testifies based upon foundational evidence. And so when his foundational evidence crumbled, the administrative law judge did not believe Dr. Khatri. He testified that because Dr. Zospah had trouble during her program, that the 3 years she completed, which statutorily are sufficient for licensure in California, a fact of which the ALJ took judicial notice, Dr. Khatri was just not credible and worthy of belief. He testified, and we've quoted the portions of the administrative record in our brief. He testified that he never read the statements of issues in this case. He never read the guidelines the medical board has for expert witnesses on what you're supposed to do. His reports were devoid of any mention of what's the standard and definition of incompetency. And instead, he focused on Dr. Zospah having trouble with her ABSITE tests, which are a predictor in a residency program about your surgery board certification. And everything that he had to have concern about had to do with testing. And I'm not going to spend time on 15 minutes talking about the tragedies Dr. Zospah underwent during her residency program. And I encourage you all to ask her about them at the end. but she got bombed in her test taking abilities by losing a brother, a sister, family tragedy, taking care of parents. No reasonable person could have focused on test taking during the residency. Yet she managed to complete 3 years of her residency. The ALJ took judicial notice that that was sufficient. And what you're going to hear from opposing counsel is that the 3 years, they were just kidding. They really didn't count. She didn't do well during the 3 years. That's not what the evidence in the record says, and that's not what Drs. Sticka and Dyke from the program testified about. The board relied entirely on an expert, non-percipient witness who read North Dakota documents and didn't read them in accordance with the standard, and the ALJ didn't believe him. And he didn't apply any standard. So the legal issue here is Dr. Khatri's testimony worth anything because he didn't read the legal standard, he didn't have a standard of incompetency, and he didn't know what standard he was even applying. So as a matter of law, the board, even after non-adoption, can't consider him. As a matter of fact, he wasn't credible because he hadn't reviewed enough stuff and he didn't know how she really practiced. I got him to concede on cross-exam that based on his review of what Dr. Marriott's reports were about Dr. Zospah's performance for 14 months at Advantage Wound Care in Southern California, that she could in fact practice independently. He said so, he admitted that on cross-exam. So therefore, the uncontroverted evidence in the record is that she can practice independently. And that's what the administrative law judge hung her hat on with respect to finding probation was inappropriate. Let's talk about probation being inappropriate. Again, she'll take it. We asked for it. And if we would ask that if the board thinks that probation is the way to go to protect the public from Dr. Zospah, that we would ask for 2 years and 11 months to allow her to petition for early termination, because once the board sees after a year of her resuming practice with Dr. Marriott, which I'll get to in a minute, we believe the board will have no concerns whatsoever. Nor maybe should the board have concerns from the administrative record as it is. So while she was in her program, Drs. Dyke and Sticka talked about how she did. She was skillful, her patient care was great, she had test-taking struggles, and just couldn't move on because of the onerous nature of a surgical residency. The board's counsel has characterized this as she can't be a doctor at all, she's not going to be a good doctor, she didn't really pass, she didn't do that well, but the program vouched for 3 years of completion. Under Business and Professions Code section 2096A, she got 3 years. The ALJ took judicial notice that that's sufficient. Dr. Zospah is not asking the board to grant her a license, probationary or not, to go out and be a surgeon with 3/5 of a surgical residency. She's asking the board to let her continue practicing as a wound care specialist, where she's already done that in California for 14 months under Dr. Marriott, who has a declaration in the record and testified for a long time about how she did. She's just asking to resume this. Dr. Zospah is Native American, and her dream was to help underprivileged and Native American patients. She's been able to actually achieve that dream with this temporary license she has gotten, and she's done so for 14 months in Southern California. When the temporary license expired, she on her own and Dr. Marriott on his own immediately stopped. And I'm going to get to the licensing part in a minute, but that's what she's asking the board. Let her resume this where she's been before. Unlike many probationers, she actually has a monitor, a supervisor. He's already done it. He's testified for her. He's vouched for her. She is ready to go. Hence the novelty and unique nature of the case. The Exhibit G is the document from North Dakota that proves her 3 years completion and why under 2096A she's met those requirements, which Judge Assel acknowledged. Dr. Sticka testified specifically about Dr. Zospah's performance during the program, that she has medical knowledge, training, good, caring, competent physician. Dr. Dyke addressed the issue of 3 years.
Mr. Simas, 1 minute remaining.
Thank you. The only testimony in the record about how she did, other than the paperwork, was Dr. Dyke. And he talked about how 3 years of surgical training is good training for family practice and other things, not surgery. So the Attorney General is going to argue she can't be competent to be a surgeon, which is true, but the only evidence is Dr. Dyke about her what she did learn and take away. The dishonesty I will save on rebuttal, and I will be very quick. The evidence is uncontroverted that Dr. Zospah relied on the North Dakota Board and the residency program in renewing her residency license, and upon that applied to the California Emergency Services for her California temporary license. And we'll talk a little bit about that on rebuttal, but the ALJ found her to be honest and credible, and the documentary evidence shows the chain of custody of such reliance. The dishonesty was an afterthought amendment of the statement of issues, which we contest was an attempt to sort of sideswipe the merits of
Thank you, Mr. Simas. Your 15 minutes has expired.
Thank you very much.
1 moment here. Okay, sorry. Ms. Murthy, your 15 minutes begins now.
Thank you very much. Good morning, Your Honor, and members of the board, and thank you for the opportunity to speak to you today. I will endeavor to keep my remarks brief because complainant's position on this first amended statement of issues is, I think, laid out in the written argument previously submitted. And that written argument and the crux of my argument today is that contrary to what Mr. Simas seems to have pointed to, either probation or free and clear license, there is a very important third option, and that is really the only option to protect the public in this case, and that is denying a license to applicant Zospah. I want to make two overarching points about why this is important, and then three smaller points addressing the applicant's written argument paper. The record in this case is extensive, and it is comprised of exhibits entered into evidence at the administrative hearing, 2 volumes of hearing transcripts, and a supplemental administrative record consisting of documents filed with OAH prior to the hearing and written closing arguments filed after. Those were prepared by my office and submitted to the board and to applicant. That's Bates number SUP AR1 to Bates number SUP AR391. We have a very fleshed out documentary record in this case, and that's very important because in this, as in many other statements of issues cases, documents really do speak for themselves. These are applications, application materials, and I want to sort of take this opportunity to provide a few highlights in this statement of issues case of the documentary evidence and explain why these highlights are so important. The first highlight I want to point to is Exhibit 4, which is the operative statement of issues in this case, the first amended. And that, it's important to note, states 3 independent causes for denial of the license. They are unprofessional conduct stemming from deficient performance in postgraduate training. 2, unprofessional conduct stemming from gross negligence, repeated negligence acts based on this applicant's use of an expired limited scope North Dakota training license to obtain emergency authorization for private practice in California, private practice that was ultimately unlawful and unlicensed. And 3, unprofessional conduct due to dishonesty related to the North Dakota residence license. The key point is this. These are all three independent grounds for denial. An applicant in this case has failed to overcome any of these three independent grounds for denial, that is, legal bars to her licensure in this state. California Supreme Court case Martin versus Alcoholic Beverage Control Appeals Board, 52 Cal 259, which is also cited at page 9 of complainant's written argument in this matter. This case controls here, and I think it's actually very instructive. In this case, the court stated that for the purpose of a denial of a license, it's not necessary to find that an applicant knowingly or intentionally misrepresented a material fact, that she lied even. This is, and I quote, the burden of proof was on the applicant, says the Martin court, and the department was not bound to believe the applicant's weak explanation. This is at page 266 of the Martin case. This board, like the board in Martin, ultimately needs to determine if it would be contrary to public protection to grant a license to this applicant at this time. That's what's on the table here. In this case, there is more than substantial evidence to support denial, which brings me to my second overarching point. Highlights from the record in this case. With respect to applicants' residency training, I will direct the members of this tribunal to the expert reports written by Dr. Khatri, Exhibit 18, Exhibit 19. Now, this is a statement of issues case. Statement of issues experts rely on application materials. They assess, based on this record, has this person shown that he or she is sufficiently trained in order to practice medicine safely in this state. Dr. Khatri found repeatedly that this applicant had not met that particular standard. And let me just say that it's very important to understand, this is Exhibit 9 at page A60, a letter from the North Dakota School of Medicine. This is an applicant who struggled in postgraduate year 2 to sufficiently meet the requirements of that year, went on to conditional postgraduate year 3, and really never mastered the material, arguably, of 2 and 3, that is years 2 and 3. The bottom line is it's the mastery of the material that is important for the purpose of public protection. That's what this tribunal needs to look at, and it is very appropriate to rely on the expertise of a California surgeon and physician licensed for many years, working with surgery residents at UC Davis to make that particular assessment. Now, I want to sort of shift a bit to a sort of a particular aspect of this case, which is to say, this is an applicant who applied for her licensure after this incomplete training, as it were. There was no indication that further training was sought in an accredited ACGME program. And yes, there was discussion of other areas of law, internal medicine, family medicine, but again, no importance seems to have been given to the actual proper training in those fields. Secondly, and with respect to the expired North Dakota limited scope residence license that appears to have been the basis for applicants' improper acquisition of a California Emergency Services Authority waiver to practice medicine in California. Just a couple of key points. Exhibit 6, page A32, applicant certifies under penalty of perjury in fall 2019 in her application materials to this board that she did not hold a medical license in any other U.S. state. Exhibit 13 at page A113 is a certified letter from the Deputy Executive Director of the North Dakota Medical Board, explaining what is an absolute key point in this case, and indeed one that the ALJ completely ignored, which is that the North Dakota license became null and void as soon as June 30th, 2019 came and went. That was the last day in the North Dakota residency training program for this applicant. And the validity of that license, it became null and void, to quote the North Dakota Deputy Executive Director, because that happened by operation of law, in particular North Dakota Admin Code 5002-1306 and also 5002-1307, available to this tribunal as at supplemental AR pages 30 to 31. Secondly, and even more importantly in some way, because it's completely sort of separated from questions of time, is question of scope. This was always a limited scope license that only allowed for practice in an approved postgraduate training program. So that applicant, regardless of her sort of confusion, as it were, about the temporal validity of the license, used a limited scope license for practice in California in a private practice setting. But this is an applicant who has never been licensed to practice in a private practice setting at anywhere at any time. Again, a very important issue in this case that was ignored by the ALJ. So I want to emphasize these 2 points because I think it's very important for this board to recognize that the operation of law, that is North Dakota law, determines the validity and scope of the North Dakota license that was the basis for the improper acquisition of EMSA. So for applicant to come and say, look, I've practiced for 14 months in California in a private practice setting, I'm safe to practice, it certainly misses the forest for the trees if in fact that was, as it was here, completely unauthorized, unlicensed practice. Now, what is really, really important for this board to understand is there's no amount of sort of testimony from anyone that can change the fact that this applicant has engaged in a significant amount of unlicensed practice in California, and she takes apparently no responsibility for that and does not even acknowledge on any level any sort of mistake, as it were. So I think those are very, very important issues for this tribunal to consider. I would also add a couple of things about the applicant's brief. On page 5 of applicant's brief, there's a screenshot of what appears to be a portion of the North Dakota Board's website entry on her residence license. I just want to point out that the full page appears at Exhibit 12 at A108, and it's part of a package that applicants submitted to the EMSA office. What's not evident in the screenshot is that the argument paper it leaves out the North Dakota Board's disclaimer about the accuracy of information on that page, and also curiously a January 21, 2020 date stamp. So it's a partial screenshot, and I wanted to direct the board to the full copy in the case. On page 6 of the applicant's non-adopt brief, we see a recitation of a paralegal's interpretation of an alleged conversation she had with the executive director of the North Dakota Board. I just want to note that that paralegal did not testify at a hearing in this case, and the entire, and this is perhaps the more important point, the entire putative exchange rests on a faulty premise that applicant could somehow have renewed the residence license before she was no longer not enrolled in the residency program, and that renewed license could somehow follow her to California and be the basis of an EMSA waiver. That's mistaken, and it ignores the sort of fundamental fact in this case, which is the validity as a matter of time, and also the scope of the North Dakota residence license that was the basis for the EMSA waiver is by operation of North Dakota law. It's not a question of what was on a website. It was not a question of what applicant thought at any given time. And ultimately, this board has the task of considering, was the applicant's behavior separate and apart from the knowledge issues in residency, which the licensing department was right to flag and have as the basis of denial. Separate and apart from that.
1 minute remaining.
Thank you. Separate and apart from that, the question is, did this applicant behave in a way that is professional with respect to a license? This is an applicant who's asking this board to give her a license. At the same time, she has shown a record of negligence, dishonesty. In some ways, it is important for this board to acknowledge. It doesn't matter which of the two. The question is, was this applicant responsible with the previously issued license by North Dakota, exactly as she asks this board for a free and clear license? The answer is no, and denial on this record at this time is the only adequate choice for protection of the public. Thank you.
Thank you. Mr. Simas, you have 5 minutes for your closing argument, beginning now.
Mute. There we go.
There you go.
Thank you. The state of the record is clear, and Dr. Zospah just asked the panel and its counsel, read the record. It's unfortunate that opposing counsel is really misconstruing this. There's no other way to say it. It's just not correct what she said, and here's why. She's asking you to demonize Dr. Zospah's conduct. There is no conduct. She wasn't negligent, dishonest, or anything. We have outlined in our brief in nauseating detail at page 4 and 5, citing all the exhibits, that the North Dakota board website, upon which everybody relies, including testimony from a member of the North Dakota Medical Board at our hearing, the Dr. Sticka and Dr. Dyke both testified about how the North Dakota board works from the residency program perspective and from the board program as a former board member. The board website was what everybody relied on. And before counsel demonizes Dr. Zospah in front of the board, she really ought to remember the testimony of Sonia Arango. Sonia Arango testified. She's the credentialing director for Advantage Wound Care in LA. She had been a credentialing coordinator director for a number of years. She testified exactly about the process that she went through. And she looked at the North Dakota board, and she did it just like she would the Idaho, Illinois, and Florida board. And she was not new to this process. No reasonable person in Dr. Zospah's circumstances would have believed you couldn't rely on the North Dakota board. And the North Dakota board exhibits at the bottom express the intent that this is to be relied upon by the viewer, as Ms. Arango also testified, as Dr. Sticka and Dr. Dyke testified. So there is no demonic, dishonest conduct on the part of Dr. Zospah about trying to mislead anybody. That's proven by Ms. Arango's testimony, Dr. Marriott's testimony, Dr. Sticka and Dr. Dyke. Dr. Khatri, the only evidence the board presented, didn't know a thing about it. He was reviewing the documents and he didn't know how it worked. Secondly, the other fact that shows her honesty and candor is on June 30th, when her license expired, she stopped practicing. Why would a person who's dishonestly trying to practice stop on the date she believed that the license was expiring, June 30th, 2020. She and Dr. Marriott believed that to be the date. She stopped. That was her last day. No more work. A dishonest person who's trying to scam the system is not going to do that. This was governed by an executive order by Governor Newsom based on the pandemic and the California Emergency Services Agency. That's who granted this license. The law does not say a North Dakota residency license isn't good enough for this. It doesn't say that. I also contest, although I don't think this board is interested in fighting over North Dakota law, the statutes of North Dakota do not say what council says they say by operation of law. The residency license and the testimony from Dr. Sticka talk about how it can be renewed year to year to year when a resident is going to go on to the next year. Dr. Zospah's was renewed, and after it was renewed and notifying the board from the program, that's when she and the program director decided that her test scores continued to be a challenge. So
1 minute remaining.
Thank you. This is far, far, far from a case of dishonesty at all. And it's proven by other people testifying about how the process works. Dr. Zospah had nothing to gain whatsoever by doing this. She stopped when she was supposed to, and the system under which this emergency licensure was being handled was brand new. It was pandemic based, and it was an executive order based. So the board, CEMS, Dr. Zospah, nobody had experience with this. Dr. Zospah testified about this, and the ALJ found in her finding number 25 of the proposed decision, page 8, applicant credibly testified she believes she was licensed in North Dakota when she applied for the California emergency license. It was not established she knew or should have known she was not licensed in North Dakota at the time the application for emergency license was submitted. It was not established that she was dishonest. There's simply—
Thank you, Mr. Stamos. Your time has expired.
Thank you very much.
Thank you. Ms. Murthy, your
Yes.
5 minutes begins now.
Yes, just a couple of points. I believe that there was testimony at the hearing that Dr. Zospah practiced until June 30th, 2021, which would be consistent with what opposing counsel said, 14 months of practice. That is April 2020 to June 30th, 2021. So I believe it's incorrect to say that Dr. Zospah stopped practicing on June 30th, 2020. I would also add ultimately that this is a case about what the responsibility of a licensee is to be with respect to the forthcoming provision of information regarding change of circumstances and how that change of circumstance may affect a license. Now, we know from the letter, the certified letter from the Deputy Executive Director at the North Dakota Medical Board, that shortly before June 30th, Dr. Zospah apparently recertified that she'd still be in the residency program. She may have known at that time that that was not true. In any event, the moment it became not true, that is on June 30th, 2019, she had a responsibility to say something, and she didn't. And we get further along in time, and we see that there was no inquiry made, and that too from someone who in the fall of 2019 in an application to this board said she didn't have an out-of-state license. The question is, which is it? Did she or didn't she? And in some ways, the fundamental question here is about Dr. Zospah's behavior with respect to the North Dakota license. That behavior does not show a record of due diligence or honesty. I would also add that Dr. Marriott would be a completely unsuitable probation monitor. And on page 15 of the board's disciplinary guidelines, it's stated very clearly that a monitor should have no prior or current business or personal relationship with respondent. He has been her employer. He has been someone who has been involved in the EMSA licensing. And at the end of the day, the responsibility to speak honestly about her license, to learn what it is and isn't, rests with Dr. Zospah, not with licensing clerk Sonia Rango, not with clerical staff at the University of North Dakota Medical School. This state and this board expects its licensed physicians to be forthcoming and honest, not only when no one is looking, but especially when no one is looking. This case, separate and apart from the inadequate residency training, presents these very, very serious issues. And for all of these reasons, the board should deny and affirm, should affirm the denial of a license in this case. Thank you.
Thank you very much. I will poll the panel members now to see if they have any questions for counsel. Dr. Thorpe, do you have any questions?
Yes, I do have a question. For Ms. Murphy, the issue of, I mean, clearly there's a significant amount of evidence in the record from multiple people, including her program director and her associate director, and from members of her residency program that she practiced with, that Dr. Zospah was honest, credible, an excellent doctor. She had difficulty taking tests, but in the practice of medicine, she was clearly a competent and reliable person. The details, and I recognize the problem with the timing, but my understanding is that this EMSA, I mean, it's not like the Medical Board of California didn't understand that she was a resident, that her license was a resident license. Is that correct?
Well, the Medical Board of California had no indication that she still had this active resident license. In fact, that's the Exhibit 6 on the application. The Medical Board's application indicates that she has no out-of-state license. And as for
but my point is,
I'm sorry.
The EMSA, the whole point of the EMSA waiver is to be able to attract doctors from out of state to help with the crisis in the state, including residents that are licensed as residents in other states. Is that not true?
I don't believe that the EMSA waiver and the EMSA documents evince the notion that a resident in another state can come here and do private practice. And I would direct the tribunal to the actual EMSA document, which says healthcare practitioners who are duly licensed in other states, which again, we have a problem with that in this one. But here's the important language, are authorized to perform within the scope of practice allowed by their license, that is the out-of-state license, to support medical responses in California. And that's a problem here in this case, because she engaged in private practice medicine, not in the sort of supervised context of a postgraduate training program.
So my concern, I guess my question is, it appears to me from looking at the record that it isn't like Dr. Zospah came looking for this position. She was recruited to this position by a colleague, and they recruited her under this EMSA waiver, believing that she had a valid resident license in North Dakota. That's what it appears to me to be. So I realize that there's some problem with the timing, but the issue is not that she had a resident license. The issue is she was a licensed personnel, medical personnel, licensed in North Dakota, and she was recruited here to help with the pandemic. That's my understanding of what happened here.
I think it, if I may, I think it would be it's important to think of it as she had come to California. She had already applied to this board in the fall of 2019. While waiting for this board to make a decision about the California free and clear license that she had asked for, in March of 2020, she, along with Dr. Robert Marriott, went forward on an application for an EMSA waiver, which is effectively a waiver of a California license to practice in California. And in going forward on that waiver, one of the preconditions of a waiver is a valid out-of-state license. And Dr. Zospah at that point did not have that. That's what's at issue here. And secondly, even if it were valid as a matter of time, the problem was it was a limited scope license, that is, you have to practice in a postgraduate training program. Dr. Robert Marriott was not running a postgraduate training program. He was doing private practice. This was unsupervised practice outside of the scope of any license that she had. There needs to be an equivalence as far as the EMSA waiver is concerned, and that equivalence wasn't here.
Well, I guess I'm puzzled. How did she get the waiver then at all? I mean, if they clearly saw the resident license number, they clearly
right. They and the actual package that was submitted to EMSA is in the it's in the record itself, and I believe it's at Exhibit 12, if I'm not mistaken. So what happened is she submitted a screenshot from a website. She or someone in Dr. Robert Marriott's office submitted a screenshot from a website. That website had RL13319. R stands for residence license in North Dakota, but it was not clearly marked on that particular website page. That website page said that there was an expiration date for that license of June 30th, 2021. But that's not an expiration date that the North Dakota Medical Board could ever verify, because again, given the nature of what RL13319 was. So to answer the question about how an EMSA waiver was given, it was given on the basis of a document that contained a mistake.
okay, it contained a mistake in terms of the date, but not a mistake in the fact that she was a resident.
Well, to the extent that the R is something that the people reviewing the EMSA documents would understand to stand for resident. It was not spelled out. It was not explained in that application. It's not clear from the materials, the certified materials that we got from EMSA, that EMSA knew that she was a resident in North, and that was a residence license.
But clearly she didn't not. Maybe, I mean, my point is, it doesn't appear to me that she was being dishonest. She was giving them the information. The fact that they didn't know what it was doesn't seem to me to be.
And she didn't tell them either. I mean, she didn't tell them either.
She wasn't asked, though. She wasn't asked. Okay, I'm sorry. That's all I have. Thanks.
Thank you. Ms. Campoverde, do you have any questions?
No questions, thank you.
Thank you. Mr. Brooks?
Yes, just to be really clear, at the time when she applied for the waiver, her license in North Dakota was expired, correct?
Yes, it was.
And she did not disclose that.
That is correct.
And the assumption is if you're a resident or you're a doctor, you know when your license expires, or you should know, correct?
That is correct.
All right, that's all my questions then. Thanks.
Thank you. Dr. Hielzer?
Thank you. Mr. Seamus, with regard to the letter from the North Dakota Medical Board, they mentioned that Dr. Zospah certified on June 11, 2019 that she was going to continue in the residency program, yet that was about 3 weeks before she actually finished her time in the program ended. It seems difficult to understand why she didn't know 3 weeks prior to the end of her residency program time that she wasn't going to continue. Can you comment on that?
Yes. Dr. Hilzer, as she testified and as the program director testified, that's exactly what happened. Is 3 weeks after that. So first point is she didn't control the timing of that June renewal. It was a somewhat automated, independent thing that the program did. The evidence in the record and the testimony of Dr. Zospah, and I think it's Dr. Sticka, talked about the program putting together its roster of residents for the next year. That's what happened. They put together the roster of the residents for the next year, turned it into the board of North Dakota, and that was a routine kind of thing with which Dr. Zospah was not necessarily involved in the timing. Then 3 weeks later, she sat down with Dr. Sticka, had a conversation about the test scores, what she'd completed, what she hadn't, her family tragedies, and they came to a mutual decision that she was not going to pursue surgical residency anymore. And then she was given credit for the 3 years, and they worked out her departure. She was unaware when they worked out her departure of how the disclosure 3 weeks prior had worked, the roster being sent again. And then she was unaware that the program wasn't gonna do a subsequent report or anything like that. So that, and I encourage you to ask her about it at the end here, because she can tell you that came out in the testimony, not only from her, but also from the program director. And to add on to one quick point, the reason a residency license works for the California Emergency Services is Governor Newsom's executive order talks about Government Code 179.5. It incorporates it by reference, and it says when a person holds a license or other permit. So unlike council has argued, a permit, residency permit, maybe in California it was a PTAL, Physician Training Authorization Letter, whatever it's called, it still worked for the emergency medical services. So that's how that was used and how they considered that. And then Dr. Hilzer, that's how the timing of the reporting worked. What ultimately was the issue is, was her license really renewed fully for that next year when she was going to be in the program, or was it not? And council's trying to argue that North Dakota law meant that her license expired by operation of law. That's not what the statute says, and that's not that clear. But moreover, to not make the board be North Dakota lawyers, there's no evidence of that. And the ALJ listened to the testimony that I referred you to just now of Dr. Sticka and Dr. Zospah about the timing. Then she decided to not go, but it had already been renewed for the next year before she decided that it was not good for her, along with Dr. Sticka. So I hope that answers your question.
Thank you. I have no other questions.
Thank you. Ms. Lawson, any questions? Ms. Lawson, are you still there? Sure.
Sorry to double mute. Yes, no questions. Thank you.
Okay, thank you. And I see we have Dr. Mahmoud joined us. Dr. Mahmoud, do you have any questions?
No further questions.
Okay, thank you. And I will just ask, generally, does any member of the panel have any further questions for the attorneys? Okay, hearing none, that at this point, I'm sorry.
This is Dr. Zorbais. I just had one question, and I think Dr. Brooks or Mr. Brooks has a great point. And I just wanted to make sure, is it actually, I thought that when, that's my question is, did Mrs. Zospah, Dr. Zospah, was her license expired when she applied for the IMSA? And that's Mr. Stemus.
Oh.
The question, so I think I want to make sure I heard it. At the time she applied for the IMSA, was her license expired?
Correct.
No, it would have expired during the time. There's two different expiration dates. The real one, and then the one the board reported. So during the time she applied, her residency license based on the board was still renewed and accurate. It actually expired a year before the board thought it expired, but they did not update that until such time as the California board called them, and then they suddenly updated their website. So at the time she applied for Advantage Wound Care and the EMSA, when the credentialing was done, it was within that renewed year, and the website was showing, you know, current and all of that. That's the problem.
Thank you.
Any further questions? Okay, hearing none, then at this time, Dr. Zospah, if you would like an opportunity to address the panel, you may do so. Mr. Seamus, it looks like your video turned off. Are you able to restore it?
Can you still hear me?
I can still hear you. I just can't. I can see you now. Okay.
Okay, I'm
Dr.
sorry.
Zospah, would you like to address the panel?
Yes, ma'am.
And if I could you please raise your right hand? Do you solemnly state, under penalty of perjury, that the evidence you will give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. The floor is yours.
Thank you, board members, for taking the time to listen to my case. I wanted to clarify a couple of things. I had brought to Dr. Sticka's attention on June 25th, 2019, when I noticed that because I did not meet the points for the ABSITE score, I had actually lost points, that I was going to be about, I think about 3 points away from actually passing to the next year. So when I asked them, what can I do to help with that? At that point, that's when we had the meeting. I emailed him on June 24th, probably around 9:30 after getting off work. We met the following day. That is when on June 25th that we both decided that because of my family tragedies, my difficulty with test taking, that surgery probably was not going to be an option for me. So at that time, that is when Dr. Sticka and I decided that I should step back from surgery, and that I will complete my program up until June 30th. And then he granted me that I finished that year. That is the time when I walked away from surgery. And at the time that I applied to the California license in October 2019, I did not know that I had an active license. So I did answer that truthfully when they asked me, do you have an active license? I said no, because I didn't know I did not. So when I had talked to Dr. Marriott and the Advantage Wound Care, they looked it up and they showed me that I actually had an active license. And I did disclose to Dr. Marriott and the company that I did not complete my residency, that this was a residence license, not a full license. So we went forth on trying to get the temporary license, and I was granted based on the website from North Dakota that I did have an active license. Now, as you know, sorry, a little nervous here. Surgery was my passion, and it was something that I thought I was going to do for the rest of my life. Unfortunately, circumstances changes, and so I changed with it. Wound care, I've always enjoyed it in residency. It's something that we always did as a part of our training. It was in my scope of practice in my residency training. So when I had the opportunity to work with Dr. Marriott in wound care, I jumped on it. And I am sorry that it came across as being dishonest. I pride myself on being an honest person. I was raised that way in my culture and who I am. I did not mean to come across as being dishonest. I was not. I put everything that I've said across with the board. I was honest. And I understand from your first two cases about your concerns about public safety. that too is my goal in wound care. I work with patients at bedside, and I understand my limitations of what I can practice because, at bedside, the most that I do in wound care is a debridement with a curette. And if the wounds are too complicated, and I've had many where they are infected, they need to be surgically debrided. This is not my scope. I understand that. And I recommend my patients at that time to go to the emergency room to get further evaluations and treatment that I cannot provide at bedside. Following that conversation with my patients, I always make sure that I go back to the referring physician and tell them, this is my evaluation today. This is beyond my scope. I've recommended to the patients to go to the emergency room. So I understand your concerns for the public safety. So I do have positive outcomes as Mr. Seamus has pointed out. And I would like to continue this trend in wound care by continuing to do continuing educations, attending wound conferences to continue increasing my knowledge, and to continue educating my patients and communicating with other healthcare providers that can provide a broader scope in wound care that I can't do at bedside. So I understand your concern for safety, but I will do my best to practice in the scope of wound care and with the standard of practice. I am very willing to accept a probationary license to show you that I will be safe, that I am safe in my practice. So I do ask, please consider these terms. Thank you.
Thank you, Dr. Zospah. I'll poll the panel members again to see if there's any questions. Dr. Thorpe?
I have no further questions.
Thank you. Ms. Campoverde?
No questions, thank you.
Thank you. Mr. Brooks?
No questions, thank you.
Thank you. Dr. Hilzer?
No questions, thank you.
Thank you. Ms. Lawson?
No questions.
Thank you. And Dr. Mahmoud?
Thank you. No questions.
Okay, thank you, everyone. That does conclude the oral argument in this matter. The record is closed. The case is deemed submitted, and we can go off the record. This was our last hearing for oral argument scheduled for this morning, so the panel will adjourn and go into closed session. Everyone can please clear if you're not part of the panel or somebody who should be there, please clear the room. And I will turn it back over to
Judge King.
Yes.
We actually have a separate meeting for the closed session, so the public is welcome to stay in this room till adjournment. I'd ask you to collect any information you need from the court reporter before we do leave this meeting, though, because the court reporter won't be present in the next meeting.
Okay. Ms. Melgren, are you there?
I'm here, Your Honor.
Okay, thank you. So I noted that the first hearing ended, I put an end time of 9:20. Do you have an estimated page count?
Your Honor, I did not separate them by each case. I just have a total of all three.
Oh, okay.
Is that I wasn't, because we didn't take a break. I actually have to turn my machine off to start a new file.
Okay, Ms. Melgren, let me say that if I can get a phone number from you, I can call you after the during a break or something, and I'll just get what I need for your billing information.
Oh, okay.
Is that okay?
Of course. My phone number is area code 714.
Okay.
273.
Okay.
2027.
Okay, thank you. I'll give you a call in just a bit, and we'll work out that logistical information.
Okay, thank you, Your Honor.
Thank you.
So if that's all you need, Judge King, then what I would ask you and the panel members to do is go ahead and leave this meeting. You should have the invite that has the title of Closed Session Deliberations. That will be the one to join next.
Okay.
We'll meet you all over in that room. To all the public attendees, this room will stay open again till adjournment. But you will just see a message shortly about the panel being in closed session until they return from that one.
Hey, Sean, I'm going to be probably I need about 7 or 8 minutes because I'm being kicked out of my hotel room here, so I have to find a different location, but I will be back on.
I'll let them know there. Thank you very much.
All right, thanks.
Thank you, everyone.
Thank you, Chishki.
Okay, Sean, I'm back. So this is just to the purpose, so to resume the open meeting for the purpose of adjournment for panel B on February 10, 2022. And the meeting is adjourned.
Thank you, Dr. Thorpe. We'll see you for the 2 o'clock.
Okay, thank you.